The petitioner filed an application and made objection on
You
the.
want?
My lord, we actually the date of evidence has been fixed by the learned trial judge Krishna Nagor, and if the revisional application is
Not mentioned yesterday. Yes.
Item number 102. Last occasion I mentioned before your lordship, tomorrow is the date fixed for delivery of judgment.
Delivery of judgment.
Yes, my lord. That's why your lordship was pleased to fix it on 17th. The matter is appearing.
You are confident that it will go against you.
That is why I am before the
102.
Yes, my lord.
okay, my lord.
Mention on the earlier occasion also, my lord was pleased to mark it to the list. Was just
Come at 2 p.m.
get food, your lordship.
May I
Permitted to mention.
a matter. Look, I could not mention it yesterday. I was slightly late. I got stuck somewhere else. Look, this is a matter. I'll take 1 second. This is a matter where I am the successful auction purchaser from a court sale in Delhi. That same property, almost after 12 years, it gets sold through a DRT auction. So I approached the Delhi High Court and say that give me relief. Delhi High Court said, tell me either you go to the Calcutta High Court or come to a DRT. I come to the DRT. DRT says, okay, very well, let me hear. From that order, the successful purchaser here takes me up in appeal. DR80 says, DRT is right, go back. From this DR80 order, they prefer this revision and application. There is no stay, nothing for the last 1.5 years, almost 1 year. I have not been able to get the DRT application heard out because this is pending. And I'm in complete limbo because the property that I've purchased is now being actually
Mr.
contested.
Banerjee, it is not so urgent that you cannot wait for a week. Please mention on
A
next
week.
Wednesday. Please mention on next
May I make
Wednesday because
one
of
prayer? I understand that. Not, I completely understand your lordship's pressure also. Can it be fixed on any day that your lordship?
please mention indicating the urgency next Wednesday. I will consider.
My lord,
May I be permitted to mention one matter? I'm seeking opportunity to file this revision application without certified copy. I'm not obtaining the same. Actually,
What? You are
DRT
for the certified copy.
yes, I applied. Actually, the order has been served
The order was passed.
yesterday. It was served on yesterday.
Yes.
And there is an urgency for filing this revision
What is
application.
the urgency that you cannot for the certified
Yes,
copy?
yes. Actually, I am the borrower in the matter. The matter is against this revision application against the order of learned DR80, and I am the borrower, and my ancestral property is the subject matter of the case is my ancestral property. This is the urgency.
While you have annexed the server copy,
Yes, I annexed.
leave to file without certified copy but with the server copy.
my lord, yesterday I could not mention the matter.
Madam, please mention next Wednesday.
Milord,
Mr. Banerjee
Milord, for
also mentioned. I
upgradation,
have asked
Milord.
him to mention next Wednesday.
Milord, for upgradation, Milord. In the monthly list, 700.
Why did you not mention yesterday? Please come on next Wednesday. Today is not. Please, why did you not mention yesterday? Please come on next Wednesday. Yes, call the list.
There is some urgency.
Please mention on next Wednesday. Yesterday,
My lord,
you have not
item
mentioned.
number 366, your lordship.
Yes, call the list.
Item number 1. For the petitioner, Milord, Mr. Shaunak Bhattacharya appearing for the.
Since I am not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be placed before the Honorable Chief Justice for necessary orders. Next.
Lord, I am with an undertaking, Lord. Yesterday, Lord, your Lordship said that come with an undertaking. But I'll be leaving by September. That is the only difficulty, Lord. I understand my learned friend will have. I leave it to my Lord.
Why not kindly, we want to go by merit. The conception that I break for mandatory injunction, the fiasco which is being made.
Once on merit, let it be ordered.
Kindly give me one.
Because Mr. Mukherjee, September is too long a time.
Unthinkable,
Lord, all
they have lost on all issues.
Then I'm deciding it on merits. Because, yes, Mr. Mukherjee.
The only point that I had was, Lord, I took out an application challenging the maintainability because, Lord, the degree spoke of the fact that they are in possession of the property. Whereas in the execution, Lord, they asked for recovery of possession. On that ground, Lord, I took out an application to say that the manner in which, Lord, they have taken out the execution application is not maintainable. Now, Lord, that they have also, Lord, in connection with this, Lord, the execution for removal part, they have taken out a 208 application. So that has been not
Allowed.
allowed by the learned judge.
Show me
Now,
the decree first.
Lordship, page 20.
Operative part of the decree.
Yes.
page 19 and 20.
Yes, then they applied for execution.
Yes. They apply
Where is
for
the tabular statement?
Is not
Oh, yes, it was handed
No, it
up
is
for
not
the,
part of. It is not part of, but it is your document.
yes,
I
yes,
can
on the
hand-
last occasion, your learned junior handed up.
Yes, Lord, that
I've got a copy.
your lordship has got copy. Kindly see, Lord, the 11 column number 11, and shall deliver vacant harsh possession to the decree holder if required with police help.
So you are
The last
agreed by
line.
that, after end. After
Yes,
end.
yes, because this portion I say that this is inexecutable because the court in the decree, as your
So
lordship will
according
see,
to you, executing court cannot go behind the decree.
lordship. And therefore,
That
we
will be
took
your
out an
submission.
application to say that the execution is not maintainable, which was my lord decided by the impugned order. Number the impugned order goes to say, if your lordship kindly comes to my lord order dated 18/12/2024, not about now the not in the bottom portion on the scrutiny of such prayer. This court
Which-
finds not impugned order.
Impugned order.
Lord, 18/12/2024,
Show me the application first.
lordship,
Impugned application.
lordship. Lord, that is at page 29, paragraph 4. Paragraph 2 did not pray in the said suit for recovery of possession. In the said suit, the decree holder prayed for decree for declaration and for permanent injunction that your petitioner submit before your honor to dismiss the execution on the ground of non-maintainability.
Yes. Yes. Now the impugned order.
Now, Lord, your lordship will kindly come to today is fixed for hearing of petition under 208 of the CRO for
No,
police
this
help.
is your application for non-maintainability.
Yes,
is
then
their
Lord, the
application.
second.
Where is their application 208? Because that was allowed.
208 तो लगा अच्छा तो कैसे
Not been annexed.
not annexed.
You have a copy of that.
I am asking her to.
That was allowed.
That was allowed, and Lord, my application was dismissed
Yes.
by the same order.
Yes. Do you have a copy of 208 application? You don't have.
अच्छा तो
Yes, Mr. Mukherjee.
but she's trying to find out. Lord,
Yes.
Today is fixed for hearing of petition under 208 of CRO for police help preferred by the instant decree holder. Today is also fixed for bringing further order by the decree judgment letter from learned appellate court. My appeal is pending. I could not move my stay application because the learned judge is not there. The court is vacant. Petition for non-maintainability preferred by the learned.
If the court is vacant, charge court will be there.
Lord, I know. I have told my learned junior. Lord,
The
there is no
application cannot be moved.
no
That cannot be.
that is not. I do not say that. It is the latches on the part of my client to move it.
Yes.
The petition for non-maintainability preferred by the learned advocate for the judgment debtor is taken up for consideration. Learned advocate for the judgment debtor submitted that the instant execution case is non-maintainable. It is further submitted. The plaintiff on the original obtained decree of declaration permanent as well as mandatory injunction in respect of the decretal premises, that is suit property. It is also submitted that there are allegations of keeping certain bamboo posts therein at the decretal property by the defendant judgment debtor. Decree holder now wants to remove such bamboo poles. Further, in the garb of such order, he is also going to recover possession of the property for which there was no prayer at the original suit. The learned advocate for the judgment debtor also refers an order of the Honorable High Court in Calcutta vide such and such, submits that the decree holder cannot be allowed to channelize his prayer for undue gain that does not sync with the original prayer sought in the suit for which the execution is on the deck. Learned advocate for the decree holder opposed and submits for rejection of such petition for non-maintainability. Perused petition, other materials on record considered. On consideration, it remains the opinion of this court that the degree of mandatory injunction has been passed in favor of degree holder with a direction on the defendant to remove the bamboo poles. Plaintiff of the original suit, degree holder herein, is also given liberty to execute such order and decree in case of failure of the defendant herein to comply the order and degree of this court. Now the degree holder prays for removal of such bamboo pole with the help of police and for handing over possession of the decretal property with such police. On due scrutiny of such prayer, this court finds that such prayer is perfectly aligned with the original decree and under this court and order of this court. Most of the degree of mandatory injunction empowers the degree holder for preferring application for removal of such bamboo poles with any legal recourse, including police help, so that degree holder cannot be said to press his prayer in this execution for such undue gain as stated. Defendant judgment data also preferred an appeal. He has every liberty to discard and truncate the judgment and decree of this court from the learned appellate court. But the judgment data cannot be allowed to challenge the execution of the decree by the decree holder like that.
208 has not been allowed. 208 has been fixed for hearing.
That is a non-maintainability petition, Lord, that has been rejected.
Yes, but 208 has.
Then, Lord, kindly come to the later part of the order.
Yes, yes. Mr. Mukherjee, where is the order passed in CO 2774 of 2018? Some order was
Yeah.
referred to.
Yes, my lord. My lord, your
You have a copy of that order?
Yes, my lord.
Do you have an extra copy so that Mr. Mukherjee, I think, also has not
I have not
gone through that order?
First, your lordship goes.
Please make your submission,
If
please.
necessary, I shall deliver.
Oh, this is, Lord, I know, your lordship, maybe, Lord.
I do not know, my lord, why this order was in the next page. This is the first order. Then
Now that your lordship
You are
knows-
trying to find both of us.
see the desperate attempt to avoid the court. Your lordship, that has been placed also. It
I
happened.
was thinking that some orders passed in connection with this matter. It's not this matter. Some.
That is why, my lord, I told
So
you.
you are trying to bind both of us
I-
with this order. Yes,
that
yes,
is
Mr.
why
Mukherjee.
ওটা ওই গীতাদেবী মডেলিয়া judgment.
You want to go through this?
No, Lord, I know that because Lord, we appeared in that, we lost in that matter. We know about Lord that.
Yes.
Now, Lord, my point is, Lord, that the court finding that they are not trying to, Lord, execute, Lord, that portion of the order wherein, Lord, the decree for recovery has been sought for, Lord, there is no clear finding on that effect. So far as the first part is concerned, good enough. The decree says they are in possession. Therefore, there was no necessity for asking for recovery of possession. They cannot get a recovery of possession, Lord, on the basis of, Lord, what they have
So
paid for in
according
the
to you,
execution.
this execution ought to have been restricted to the
Only
prayer for
to
mandatory
Mandatory
injunction.
injunction.
Because it was in
Yes.
the nature of a mandatory injunction.
They never paid, Lord, for recovery of possession. They never put the court fees on recovery of possession.
That was also not granted.
Lord,
That relief was not allowed
that was, Lord,
in the decree. In the decree.
in the degree, the
That
court
relief was
said that
not-
they are in possession.
So the relief of recovery of possession was not granted. Holding there in possession, permanent injunction decree was passed.
Lordship. Lordship.
Anything more?
No, that is all for.
Yes.
Now, my
But I've come up with an undertaking, Lord, if my learned friends accept, Lord,
Mr.
it's
Mukherjee,
like, Lord,
he-
if you want to say
accepting-
something about the time, I can also talk about the timeline. But Lord, that is all for my submission.
My lord, first let me submit the manner in which the matter has been moved and the interim order has been obtained. The matter was
Order was obtained.
from this court. The matter was running as like 340 or others, as we are accustomed of. Then without notice, it came.
There was
on the
no
top of the
caveat.
list.
Was there any caveat?
Yes.
Some,
So,
not served.
My lord, I am not pressing that. I am just
Move on merits because we are on the final hearing stage.
I am just drawing your lordship's notice that how powerful they are and with what gentility we are acting. Now, my lord, there is a fiasco that when a mandatory injunction is passed, order of mandatory injunction is passed, the recovery of possession, or which we call it first possession, has to be prayed separate. But what happens when the removal takes place? Here, my lord, when the removal of such article takes place, what happens? I get the possession.
You can,
I get the possession. Since the property is being used by the opposite party, by the petitioner here, by putting bamboos there, I cannot use. The property belongs to me. The court passed a decree in my favor. Court passed a mandatory injunction to remove those articles. They are bargaining on that. But what is the law on the subject? The law on the subject is clear that even if the plaintiff is couched for praying mandatory injunction, actually it is for possession. Your lordship, kindly see the Supreme Court view. This is Shantilal joined, you know it. এই জানি না ইয়ার কি হচ্ছে
1985 2 SCC 332.
Shantilal
it has been followed.
Which paragraph you are?
Last paragraph, last but one. Nice. Last but one. 337 page. I am reading it for your lordship's convenience.
337. Yes.
337 top portion. In effect, one for possession, though couched in the form of a suit for mandatory injunction, as what would be given to the plaintiff in case he succeeds, is possession of the property to which he may be found to be entitled. Therefore, we are of the opinion that the appellant should not be denied relief merely because he has couched, I impress on it to my lord, he has couched the plaint in the form of a suit for mandatory injunction. This has also been followed by Honorable Justice Arijit Paswa, and I have checked last night, 390 times High Court, different High Court has followed this judgment in granting relief.
Yes.
This is my submission, in effect. There is a misconception. We tend to say that recovery of possession, prayer for recovery of possession is a must, is mandatory in such cases. Mandatory injunction itself does not do the good, but the law has been settled otherwise. I invite your lordship to approve this. If your lordship approves this, I get the relief.
প্লেনটা আছে তো
This judgment has been followed by Honorable Justice Arijit Paswa, Justice Thakkar. This is AIR online.
Give the citation to Mr.
This is AIR. এটা লিখে নাও। এই যে civil
Which
appeal,
paragraph you are relying upon?
জোসেফ সেভারেন্স
Joseph Sevan. না আগে নম্বরটা লিখে নাও, নম্বরটা সিভিল অ্যাপিল নম্বর 3818 of 2000 এর থেকে পাওয়া যাবে।
Which paragraph you are relying upon?
Paragraph, long paragraph. It is at page last but one, at the middle portion. Shantilal Join has been
Yes.
In the present case, it has not been shown to us that the appellant had come to the court with the suit for mandatory injunction after any considerable delay.
So this was quoting from
This was
Santla.
quoting, and this is the approval. This judgment has, this present judgment has approved Shantilal Join. Generally, we escape this. We tend to say there is a practice among us to apply that mandatory injunction itself is not sufficient, but mandatory injunction is sufficient. I argued this before Honorable Justice Jyoti Bhattacharya at room number 7 also. But at that point of time, the orders cannot be obtained from High Court website. I forgot it. I applied it before Honorable Justice.
Yes, Mr. Mukherjee, anything in reply?
Lord, in paragraph 4, I'll just read it for
Of
your lordship
which?
in the of the plaint. Those judgments are rendered in the context of Lord eviction of a licensee.
No, Milord. Now let me explain this. What is the status of the
Yes.
petitioner? What is the status of the petitioner? Law at first instance is a subject of definition. I may not find the definition, but the court finds the definition. If the person is not owner, I am the true owner. He has to be either an occupier, a licensee, or adverse possession, or a tenant. Title, what we mean is the English meaning of title is relationship. What we tend to understand is, do you have any title? It means, are you the owner? No. Title means relationship of the person with the property. Like our title also. Your lordship is Bhattacharya means your lordship has a relation with Bhattacharyas. So title, no. Title, Bhattacharya is a title. It is
Mr.
Nayad Bhatto Vedanter Acharya. If you pass 2 examinations once at a time, then you get the title Bhattacharya. Now it is obsolete, but it is dangerous. All persons are not
But
Bhattacharya.
anything more? Anything more?
Now, my lord, what happens then? If I do not pray for possession, I get it.
I followed your argument. It is not necessary to pray for recovery of possession.
But we know this, that it is necessary. This is our concept.
Yes, Mr. Mukherjee.
Lord, in the paragraph 4 of the plaint, Lord, I'm reading out and then handing over to your lordship. Lord, they say, in no uncertain terms, the remaining land measuring 6 kata, which is the subject matter, more or less, which has been known.
What is the suit property?
Lord, that is the 6 katas of land, Lord, at premises number 140 by 44B.
Decree, the photocopy is not very legible.
That is in Ram Kumar
Page
Park.
23, but
I've got a copy of the plaint.
You have a copy of the schedule.
I've got a copy of the plaint and the schedule. At paragraph 4, they say that they still remain in occupation under the plaintiff. 1. Then, Lord, I go to the plaint to find, Lord, their prayers. A decree declaring that the plaintiff is the absolute owner of the suit land and the plaintiff has full right to construct boundary wall or any construction on the suit land. Then, Lord, permanent injunction restraining the defendant number 1 and 2 and their main and agents from offering any resistance to the plaintiff to raise boundary wall on the suit property and or from disturbing the plaintiff's peaceful possession on the suit property. C. A decree for mandatory injunction directing the defendant to remove the bamboo poles lying in the suit property, and in default of compliance, the plaintiff may be permitted to remove the bamboo poles from the suit property through process of court if necessary. So, Lord, nowhere, Lord, there was a question of that they are not in possession of the property and for recovery. This suit was, Lord, valued at rupees 1,000. Now, Lord,
Not at market value. According to you,
even if they're asking for a recovery of possession, Lord, this is, Lord.
sir, you have given, he is now replying.
So, Lord, I'm sorry, Lord.
Yes.
Now, Lord, in paragraph 4, they categorically say that they are in occupation. They could not put up the boundary wall. Now, Lord, they are trying to improve their case by themselves going beyond the degree to say, kindly also appoint a police or, Lord, the bailiff to also deliver possession to me. So, Lord, that portion of the order which the court says that it is in consonance with, Lord, the decree, in my respectful submission, that is, Lord, an invalid portion of them.
Anything more? Mr. Mukherjee, please give me a copy of the plaint.
But your lordship,
208, you do not have a copy.
But 208, Lord, I don't have a copy. Check that.
Can you give it, give a copy in course of this day?
But I'll just ask. Parvi Baba Ante.
Can you get a copy of 208 in course of this day? 208 petition.
Copy of the application we filed.
Yes, 208.
Police application.
Police cell. And did you file any objection to their maintainability application? If you have filed any objection, please give copy of that to the maintainability, to their maintainability application. And 208 also the objection also, if they have filed any objection. Ashun. Heard the learned advocates for the parties.
Grateful. My lord, I am for the petition.
Yes.
My lord, this matter arises out of from a ejectment suit pending before the learned civil justice junior division, Bidhannagar court. Dear lordship, if your lordship kindly come to the order dated 6 December of 2023.
Yes, give me a minute.
If your lordship kindly come to order dated 6 December 2000.
What do you want?
Your lordship, expeditious disposal, because
For what?
for the
Ejectment suit. What is the stage of the suit?
the stage of the suit is that one commissioner report has been filed, and thereafter hearing of the repairing petition filed by the defendant to be heard. But
The
since
defendant
then-
has filed a focus petition.
no. For the last 3 times, they have not appeared and they have not taken any steps, your lordship. And on the last occasion, on the 7th of March of this month, they have again not appeared, and the matter was deferred till 11th July.
What is the order passed on 7th of March?
7th of March, my lord, as no steps was taken, only for want of justice, the matter was deferred to 11th July of 2025.
Ashun. This application under Article 220.
My lord, I am applying for the petitioner wife in this matter. The application has been filed by the petitioner wife under section 24 of Code of Civil Procedure for transfer of one matrimonial suit, being matrimonial suit number 63 of 2024 from the Court of Learned Additional District Judge Second Fast Track Court at Ladulbagh, Murshidabad to the Court of Learned District Judge at Malda. The wife is residing in Malda since 2019 when she was driven away by the husband and the in-laws for the reason that she and her family members could not fulfill the demand for dowry. And she has also, the husband is already contesting one application under section 25 of CRPC filed
You
by,
have appeared in the matrimonial suit.
no, my lord.
Yes, yes. Why are you saying no? Kindly come to the order dated 3rd of October 2024.
The
We have filed a petition praying
The
for time.
instruction.
So date was fixed for on 7th of January for filing written statement. Did you file your written statement?
No, my lord, as per my instruction that we have not appeared yet. My lord, the husband.
Recording. I cannot.
My application under section 24 of the Code of Civil Procedures of transfer of the proceeding, my lord. I am the wife. I have been residing with my two minor children, my lord.
What?
Yeah, transfer of matrimonial the divorce proceeding from my lord Katwa to Bishnupur, because my lord, I am now residing at Bishnupur along with my two minor children, my lord. One children cannot speak even, my lord. I have no income at all, my lord.
What is
Well,
the stage of the
Stage,
suit?
my lord, the summons has been served, my lord. First date was 18th March, my lord. In the meantime, I have filed the application before lordship, my lord.
This application under section 24 of the Code of Civil Procedure is at the instance
My lord, the respondent of the petitioner before your lordship. My lord, in the instant case, my lord, the respondent number 3 died.
respondent.
Number 3 died.
You are the respondent.
Respondent petitioner before your lordship.
Yes. Which respondent you are?
Respondent number 3.
You are the respondent number 3.
Not I am for the respondent.
What are you are asking in the title appeal?
Plenty of respondents. There are several respondents. Mal out of several respondents, my lord, respondent number 3 died.
Yes.
My lord, died, my lord. My lord, I filed a death report before the learned court below. My lord, the
So you have
respondent
complied with order 22 rule 10A.
my lord, died, my lord, on February 2021. I, my lord,
Died on
filed
February.
13, 2021.
Yes.
On April 6,
Respondent number 3.
3. My lord, on April 6, 2022, I filed debt report to the learned court below.
April
6, 2022.
filed death report.
Debt report to the learned court below. And on June 28, 2024.
June
28, 2024, they filed an application for substitution only. After expiry of 3 years from the date of the respondent number 3,
order 22 rule 4.
rule 4. My lord, your lordship knows very well, my lord, if a party dies, my lord, application for substitution is to be filed within 90 days. If my lord, the party comes between 90,
What happened? What did
if the party,
what did the appellate court do?
my lord, court has allowed the application for substitution, my lord, without setting aside a abatement. Because after expiry of 90 days, my lord, there is no suit. Abatement is automatic. There is no appeal at all.
Where is the recent decision of the Honorable Supreme Court?
My lord,
Past, I think 1 month back.
that is not the, but it is, says, my lord, there is no appeal at all after, my lord, expiry of 90 days.
Recent decision, 1 month back, authored by Honorable Justice Dipankar Datta. Not brought that.
Okay, have a look at this list.
What is
There
the
is-
citation?
This is my 2017 Supreme Court 2419. Here says, my lord, after expiry of 90 days, there is no appeal at all because abatement is automatic. My lord, it is dismissed as abated. Unless and until, my lord, an application and order to do line is filed, substitution, setting aside abatement, and section 5.
You
Paragraph
have
number,
not brought the subsequent latest decision.
paragraph number 18 onwards.
Of 2025, you have not brought.
Paragraph number 18 onwards. Right hand side, my lord,
Paragraph number,
18, 18.
but it did not take into consideration 2003 volume 10 Supreme Court cases. Not considered.
But this is the, my lord, he is required to make application for substitution for setting aside abatement. After expiry of 3 years,
2003 volume 10 SCC. What did the Supreme Court say? Allowed.
allowed, my lord,
What
without,
happened here?
my lord, not a single, my lord, line has been, my lord, no reason has been assigned. Not a single line has been stated in the application also. They lived in the same locality, same, my lord, address. After expiry of 3 years,
Mr. Halda, file a written notes. I will keep that with me. I will consider when you will be applying for setting aside abatement.
can you consider this? No,
2025 judgment you have not brought, Mr. Halda. 2003 not considered. That also you have not brought.
let me
Because
come back.
that is against you. Anything more?
Let
I
me
will
come,
consider this.
let me come back with those decisions. Let me come back with those decisions.
Not necessary. Come.
Well, kindly consider, there is no
ডোন্ট টেক ইট, এটা লাগবে তো দিয়ে দেবেন কিন্তু আমাকে, এটা ফাইলের মধ্যে গুজে দেবেন না, আমাকে দিয়ে দেবেন।
ফাইলটা দেবেন
এই
তো,
দেখো।
prospective correction করতে হবে।
Mr. Bhalla, take it back after it is transcribed. Yes, for the next matter.
I am there. Partition suit for partition. Order of injunction, ad interim order of injunction was passed, directing status quo to be maintained. But thereafter, defendant number one filed an application under section 151 for permission to complete. According to him, it was a incomplete construction. Permission to complete it. But we filed our objection that he is already occupying the admitted share portion. Total property is 1 to 6.25 decimals, 5 co-sharers, each is entitled to 1.25. He is already occupying and have his property on immovable property on 1.25 decimals of land. Now he is making construction.
You are residing in the same property.
Same property.
So you have constructed a house. There is already an existing
No,
house.
my property is elsewhere. Vacant portion, John vacant portion, he is against.
So you have not constructed here
I have,
in this suit plot.
yes.
You have constructed also in another portion.
Another portion.
But you don't want your
He has
co-sharer to
already his portion.
shoot for partition. He will not claim any equity. Let him
No, that
construct.
is there. That is only on that basis order was passed. But 125, 151 is not applicable. 151 is not applicable.
151 is not applicable. 227 is then also not maintainable because it is modifying the order. 227 is not maintainable. Approach the appellate court. You will be taking a technical point. Court will also take a technical point. 151 is modifying the order of injunction. Appellable order.
Order 39, 1 and 2.
Yes. So by 151 modification, 227 not maintainable.
Another point is that is technical point. Apart from that,
some technical point is against you. Don't take those technical points.
apart from that, but this is specific allegation is that it is without any sanction plan. But the construction is
Without any sanction plan.
without any sanction plan. And that aspect has not been
You
dealt.
know what remedies are to be pursued without any sanction plan.
That has not dealt.
After all, your co-sharer,
Dealt
let
with.
him construct.
Learned court has not dealt with.
And I can
On it.
expedite the
Only on the basis of undertaking that
I
he
will
will not-
expedite the partition suit.
that is there. But one judgment I am relying on if unreported. Justice.
For what?
In case of unauthorized construction, no permission should be granted.
You take steps. If it is unauthorized, I will give you liberty to take steps. But here, where have you stated that it is without any sanction plan? Where have you stated?
Paragraph 30. Can you come to page 36?
Yes.
Page 36. That is the second page of my written objection.
Yes.
Running first continuing para then উক্ত শশী ভূষণ ব্যানার্জির পুত্র উদয় শঙ্কর ব্যানার্জি তার পিতার মৃত্যুন্তে নিজ অংশে 1.25 ডেসিমাল সম্পত্তি
All right. So I will say that without sanction plan, they cannot object. They will not construct, but he will not raise any objection at the time of sanction plan, being a co-sharer. Agreed? At that point of time, you will say, no, I am a
No,
co-sharer.
but it is behind my knowledge. No. Sanction they have obtained, but without sanction they have done.
Let him construct. I am expediting the suit. You will be getting your share. 23. Yes, next.
My lord, item number 8, I am for the petitioner. Plus, this is section 24 application, my lord. Act 8 Miss case was filed, my lord, in the court of Nodia Krishnanagar. I want this suit, my lord, to be transferred to the Tomluk. Tomluk, my lord.
Why?
My lord, why? My lord, as because, my lord, kindly come to page number 21. My lord, divorce dispute between the parties where the decree of divorce between the parties were passed on, my lord, 18 June 2019.
The degree of divorce has been passed.
Yes, my lord. Thereafter, after 3 years, the opposite party have filed one application under Act 8 for maintenance. After 2 years,
For maintenance,
for Guardian and Wards Act, under Guardian and Wards Act,
for custody.
for custody. Well, after 2 years of filing of the suit, my lord, has issued the summon, and 5th April is the date fixed for appearance, my lord. Is a ready appearance.
6th of April.
5th of April.
This application under section
In this matter, I am appearing on behalf of the petitioner. I am for the applicant bank, my lord. My lord, the opposite party has taken a loan from me, and we have started.
you want, which order you are challenging?
My lord, injunction order, my lord.
Injunction order in a suit.
Yes, my lord.
Can it be challenged in a
My lord,
227?
My lord, one thing is that there is a bar in section 34 of Surface Act. My lord, it's a quite clear, my lord. Once if surface the
Can
act.
you not take that point in the appeal?
My
Can you not take that point in the appeal?
No, my lord, if there is a clear bar, my lord, the learned lower court cannot proceed with it. They have already they
File an application under Order 7 Rule 11. Have you filed that?
no, my lord.
Then you are not taking steps. You are
My lord,
challenging an appellable order under Article 227. You are not taking the appropriate steps.
my lord, one thing is that, my lord, my lord, I am not going to the variety of injunction. My lord, my question is quite clear, my lord. But if there is a bar, that act surface act clearly barred, my lord. So lower court cannot proceed in this case, my lord. I have started action against surface.
What steps have you taken in the learned trial judge stating that the suit is barred? You have not taken any steps.
My lord, I have filed written objection, my lord.
File your written objection, it will be considered. I am directing the injunction application to be decided.
My lord, one thing I pray for, my lord. My lord, kindly fix the date before the learned court for validity of this suit, my lord. Order 7 Rule 11. If I will file that petition in the law.
You have not yet filed.
But
You have
then-
not yet drafted. Nobody knows
My
when you will draft. You have not filed and a direction will be passed.
my lord, one thing is
Yes,
that, my
yes,
lord,
yes.
section 34, if there is a bar in section 34,
This application under
In your lordship, I appear on behalf of the petitioner. Lordship, judgment debtor is the petitioner before your lordship. Lordship, the suit was for declaration of tenancy and permanent injunction.
Suit is for?
Declaration of tenancy and permanent injunction.
Yes.
Suit dismissed, but the counterclaim sustains.
Counterclaim for eviction.
Eviction sustained. They went for opposite party went for execution of the counterclaim. My client filed stay against that stay for appeal for that dismissal of suit. And now the opposite parties file application for occupational charges. I am only agreed for by the quantum of the occupational charges.
You are not agreed by the stay order. Madam, it is a composite order. I can vacate the order. Entire order. It's a condition. Stay on condition.
Lordship.
So you cannot be agreed by a part. Either entirety or you have to accept the entirety.
We have stayed the stay for the execution of that
Yes. So that was granted on condition.
condition. But we are ready to pay the occupational charge. Lordship, kindly see the
What is, according to you, the market rate? What is the area?
Lordship,
Under
kindly takes up my schedule of the plane. The two tile shed room, your lordship, that can't be
Two
2,000
tile shed room. What is the area of
8 by 9 feet. Lordship, kindly see the condition, absolutely broken, and he is a very poor person.
Madam, kindly vacate. Ask your client to vacate. Don't stay in that. It may collapse at any point of time.
Lordship.
So it may cause harm to your client. So ask him to move to a better accommodation at a lesser amount of rent. You need not pay 2,000. You will be getting a better accommodation at a lesser amount of rent. Please move there.
Lordship, other renters, there are 26 rooms. All are
Did the
like
client come to you? Did you inquire? So what is the market rent if the client has to move to
other renters are giving.
a similar accommodation in the same locality?
Lordship, other renters are giving 240, 250 rupees for
Because then the decree of eviction has not been passed. For that, Artharam has come. Only for that, Artharam has come.
Lordship, kindly takes up page 50.
Madam, entirely I can vacate the order. Stay with condition. There is no stay. Let the execution proceed, or it will remain.
Kindly
I will
consider
not
very
allow
poor
peaceful challenge.
ready to give the occupation charge, but not 2,000, your lordship. He can't because he's a very poor person. Only the quantum of the occupational charges.
With effect from which date?
From date of filing of the appeal, lordship.
What was the date of the decree?
Date of the decree was lordship, I'm just saying.
29th of September 2022.
Lordship.
The law is from the date of the decree. Not from the, so you have saved 3 months occupation charges in that. So if I direct issuance of notice, they will come and challenge this, ask from the date of the decree. You have saved 3 months occupation charges.
But lordship, kindly consider he's a very poor person. Lordship cannot give 2,000 rupees per month from the date of the appeal, your lord.
2,000? Nothing. Which area? Srirampur.
Srirampur. Not Srirampur, Uttarpara.
Srirampur stalwarts are staying.
Uttarpara, lordship, not Srirampur.
Srirampur stalwarts were not staying.
Stalwarts are staying. The suit property is in Uttarpara.
Uttarpara stalwarts are also staying there. So it has to be increased. Ashun. This application under Article 227 of the Constitution of
Hello, I beg to appear for the petition.
Yes.
The petitioners are tenant under the Kolkata Port Trust. There is a long-term lease from 1990 to 2000 for 10 years. They continued in occupation. Thereafter, they continued in occupation with the payment of rent. There is an eviction notice that was not acted.
Public Premises Act,
Public Premises Act,
Section 9 appeal dismissed.
dismissed. After payment of
What is
20
your point in these civil division applications?
My lord, kindly come to the order impute. The order has been, the appeal
You
has
did not place the entire order. Tell me what is the point you are trying to raise in this civil
Yes,
division
ma'am.
application?
The thing is that my appeal has been dismissed on the ground that I have no locus standi to go to the appeal under section 9.
Why?
Because the appellate court has,
Why? On what ground I am asking you?
under section 15, there is a bar for going to the, before the civil court. But the bar is that before the court already cannot go to the civil court, they will go to the estate officer. I will go to the higher forum for the appeal under section
On
9.
that ground, the appeal was dismissed.
One of the grounds.
One of the grounds. The merits was entered into.
Made sure entered into.
So the locus standi point is may not be very
But-
relevant. Yes, on merits, what do you have to submit on merits?
My lord, the thing is that the show cause notice has been issued after 17 years of the filing of the application before the estate officer. The honorable
There is a time limit for that.
my lord, that there is a judgment before the court by a coordinate bench of this honorable court that law of limitation applies to public premises also. So I relied upon the judgment. But the learned appellate court also the learned estate officer, they relied that there is no limitation for going under the Public Premises Act. They have mentioned one judgment passed by the honorable Madhya Pradesh High Court. There is no limitation for public premises. But our court, in a matter, Shalimar Paints matter, kindly come to paragraph number 18 of the judgment. On the basis of the Atmaram judgment, we have paid 23 lakhs according to the order by the learned appellate court. We are still paying for our charges.
At what rate?
At the rate fixed by the learned appellate court. And after the dismissal of the appeal, we are paying. They are taking. Now, after dismissal of the appeal, we have paid. They have also acknowledged.
At what rate?
15,050 every month.
15,000.
50 every month. And
What is the area of your occupation?
oh, that's 150 square meter. 150.50 square meter. 150.50 square meter.
Square meter.
Square meter. We could not given to file reply to show cause even before the learned estate officer. There is a mandatory provision under the Act of 1971.
Show me where have you raised this point
Which,
before the appellate court?
pardon my
Show me where you have raised this, where you have placed this judgment before the appellate court.
My lord, we filed one written notes of argument before the learned appellate court.
But you did not make that argument at the time of
Yes,
oral
yes,
argument.
yes, we of course argued. It is on the record, my lord, before the learned appellate court. We have filed it. We have filed 3 judgments. One of them with the Saliman Prince, another is Atmaram, another is recent pending proceedings before the Honorable Supreme Court, where Honorable Supreme Court has observed in a pending proceedings that in such cases where there are, my lord, the exact wording is where there is question of many persons involved, but that
Right.
to be considered.
I'm coming after 5 minutes.
Okay, my lord. We are Yes.
Which notice is, according to you, is time barred?
My lord, the show cause notice that is given in 2020, after elapse of almost 20 years from the date of
Section 4 notice.
Section 4 notice.
Yes, when the proceeding was initiated?
In 2002,
Yes, and
show cause notice was given in 2020.
no, proceeding has to be initiated by the issuance of that notice.
No, proceedings was initiated by the Kolkata Port Trust Authority by filing a plaint before the learned estate officer that there is unauthorized occupation.
Yes,
This in 2002.
yes.
That is at page number 20.
How did the appellate court deal with that? Show me.
Yes. My lord, kindly come to page number 13 of the order impute. There is an internal page.
Internal page 13.
13. Last paragraph. I am reading, my lord, for your lordship's convenience. One question was raised and agitated by the appellant before the competent authority that the so-called notice was upon them was issued after 17 years under law. Competent authority mentioned that they never issued the so-called notice upon the appellant without any basis because they made themselves satisfied regarding the grounds of eviction and without query to SMP Kolkata under section 8 of the Act of 1971, they could not have issued any so-called notice to the appellant. If it has been mentioned in the order that the appellant as lessee of the property was under an obligation to hand over the possession in its original condition to SMP Kolkata after expiry of the lease period which actually occurred in the year April 2000. The order further mentioned the lease could not be renewed because no option was kept in the lease agreement. So question does not arise after pay that the clear consent of SMP Kolkata, the appellant was occupying the suit premises in question legally, that too against payment of rent. My lord, at page number 180, they have estate officer also dealt with the matter, relied upon a judgment of
Yes.
Grateful.
Arises out of DRAT proceedings at the ad interim stage. Now, I am neither the borrower nor a tenant, neither a lessee. Now, may I just place the facts for once, my lord? Initially, there's a registered agreement for sale in respect of the secured asset. So, with the respondent, with one of the opposite parties for prisoner party number 5. Subsequently, I obtained a loan. I repaid the loan or a different financial creditor. Thereafter, there's a deed executed in my favor by the said promoter.
By the
There's a opposite party number 5, who's the developer of the property.
opposite party number
Number
5.
Who's the developer of the property. My lord, kindly sees the registered agreement dated 24th of
No, no,
October.
opposite party number 5 is the developer.
Developer.
So he executed a deed of conveyance in your favor.
Initially, registered
And
agreement for
the
sale.
loan was by Aditya Birla Finance.
No,
By a separate.
by a separate.
Yes. What happened after that?
After that, my lord kindly comes to page 10.
No, no, tell me the facts. Thereafter, I will look to the.
There's a closure of loan account. I've repaid my loan. KMC issued a no outstanding tax certificate in my favor, granted me a mutation certificate. I'm in possession without any hindrance. Subsequently, my possession was obstructed by the respondent opposite party number 3 and 4.
Possession obstructed means.
Disturbance to the possession.
Yes.
3 and 4.
3 and 4.
3 and 4. Who are the borrowers? I file a complaint before the Behala police station, registered as an FIR.
That disturbing your possession.
Disturbing my possession. Pendency thereof, I came to know that the opposite party number 1 and 2, who are the financial creditors, they have granted a loan to the 3 and 4 on the basis of the property which was sold to me.
Same property.
Holding number different. The previous holding number was given in the subsequent deed, and the holding number which is current given by the KMC is appearing in my deed. That their deed.
No, why there is a difference in the holding number, but the property is same.
Even the creditor claims in the DRT proceedings the properties are different, but still they are coming to my property. If they claim the properties are different, I have no idea why they're still trying to evict.
So why the holding number is different?
Previously, it was 102/76.
Yes.
Subsequently, it was changed to 102B. My deed reflects that. Their deed reflects 102/76. Now, my registered agreement for sale was done in 2016. My deed was registered in 2019. Their deed was registered in 2018, in between. But my agreement for sale was a registered one.
Agreement for sale does not create any interest.
Absolutely not. I'm not praying for that. But a registered one creates an embargo upon the financial. Section 3 of the Transfer of Property Act. May I replace the
agreement for sale does not create any interest. So where is the bar?
Going for a civil.
If no interest in the property is created in your favor, where is the bar?
My lord, may I place section 3 for once? No.
Transfer of Property Act. Order na. Transfer of Property Act.
It's an interpretation clause, a person said to have notice. May I read, madam?
Yes.
A person is said to have notice of a fact when he actually knows a fact, or when, but for willful abstention.
Registration is the knowledge. There is no dispute with regard to that.
Now, at the time of.
There is the bar in transferring. After
there is no bar in transferring. There is no bar in transferring. May I, my lord, kindly answer something. Even in section 19B of the Specific Relief Act says, I can enforce my agreement for sale.
Your agreement for sale.
It has been registered as a deed of sale in the meantime. Now, what has happened? The bank at the time of financial creditor, at the time of granting the home loan to the respondent number, the opposite party numbers rather, 3 and 4, ought to have taken due diligence with regard to the encumbrances of the property. If they do not have any due diligence at the time of granting of loan, they have no right to proceed against under the SURFACE Act. They can go before the civil court, pray for a money decree from those opposite parties. But since it cannot proceed in a proceeding under SURFACE Act. There was no due diligence because my agreement was registered and the knowledge comes from section 3. They have no right to proceed with the SURFACE proceeding. Now, I have purchased the property, I have paid, I had a loan, I have repaid. Every document is annexed before your lordship.
You sue the respondent number 5.
There's a separate,
You sue
no,
the
my lord,
opposite party number 5, no dispute.
I
with regard to
have
that.
sued. There's an order of injunction. It's a separate suit.
Proceed against that.
But they can, my lord, it's a civil court jurisdiction. I cannot implead the bank with regard, because they have nothing against me. The deed stands in my favor. There's a remutation certificate stands in my favor. The official stand of the, I'll show from the official stand of the financial creditor, the properties are different. How can they proceed against me? I'll show before your lordship.
You are the first purchaser of the flat, or you are a transferee from someone.
No, I am the first purchaser. Even my sale deed in the recitals show that my deed, my possession and my agreement for sale is in the recitals of my sale deed. I have a sale deed as well. But since the holding number is different, the registration authority did not create any issue. It registered two separate deeds. Now they are proceeding as if the loan was taken against 102B, where I am. The loan was taken against 10276. That is why they say.
Show me that you raised this dispute with regard to the holding number before
Yes, my lord.
appellate tribunal.
My lord, their opposition, I'll show from their opposition that they have admitted. My lord, kindly comes to page 156, which is the second
No,
volume.
show me for this. You have raised this point before the appellate tribunal. And what is the date of mortgage?
14th of June 2018, mortgage by the 3 and 4.
Mortgage by 3 and 4 is
14th of June 2018.
yes, and your deed of conveyance.
Their
is
deed of conveyance after that. 30th
your
of
deed of conveyance.
27th of February 2019.
So it's subsequent.
But
Mortgage is prior.
But the
This could not have
financial
been- no
institution,
conveyance could have been registered.
the financial institution who had to have due diligence with regard to
That is-
proceeding.
That
No,
is
my lord.
between you and your financer.
No, my financer is there. I have cleared my financer. There's a no outstanding due certificate. I have cleared. I have no embargo upon the property created by myself. Even there's a criminal proceeding. While obtaining bail, the promoter is accused therein. The promoter's submission is recorded by the learned trial court. My lord, kindly sees order, which is at page 130. The orders passed by.
What happened to the surface proceeding?
I 17-1 application along with the IA I preferred for stay of the order passed by the CJM Alipur taking possession of the property. That was refused, saying since I have no
Possession taken.
not yet, I am in possession. Entire second floor they have mortgage. There's two separate flats, 500 square feet of which I am in occupation. I am the owner, and my name is recorded in the. Now kindly comes to page 115. That is orders passed by the ACJM in Behala PS case, where the promoter admits that he has sold a different, mistakenly sold a different property, and he has given the money back to the opposite party number 3 and 4. I'll kindly sees that portion. 115.
115. There are 2 page numbers.
Absolute right. My lord,
There are
absolute-
2 page numbers.
And I
Which 115?
apologize, my lord. 130, it will show 130 and 115.
130 and 115.
115. First paragraph. Subhash Mahato is the opposite party number 5, who's the promoter.
This is something before Behala police station.
Yes, this is a pending before the ACJM. I lodged a complaint immediately.
Yes. There what happened?
Hard learned advocate for the accused Subhash Mahato is the opposite party number 4, who submits that due to bona fide mistake, the accused has sold second floor instead of first floor, and realizing the mistake, accused has returned the amount to the purchaser, who the accused number 2. That is 3 and 4 herein. Online, as such, his innocence paid forward. That is the stand. And if at the current stage,
Show me that you have raised this point before the tribunal.
this is the documents I have annexed.
Maybe you have annexed. You
Yes,
have annexed
yes, yes, I have.
many documents, but show me that you have raised this point.
Yes, my lord, I have.
Show me.
Yes. Yeah. My lord, page 25 or 40, my lord, if I tender my
No, impugned order.
impugn. They did not. This is 2-page order.
Show me that you are hard. Show me that you have raised this point.
It's my lord, page 2. My pleadings are there.
Maybe you
No,
may have.
I
may have raised. This is a 2-volume civil revision application. You may have stated many facts.
No, my lord, my application,
So-
I can show only from my application.
Then
If the
go back.
order doesn't record my
Did you
submission.
raise this point before the appellate tribunal?
Yes.
So go back. That point was not recorded.
No, my lord,
File a review.
may I show one more thing?
File a review.
Page 11156, my lord, kindly up second volume.
Not from that. Show me from the impugned order that you have raised this point.
My lord,
that
if
it
the
was
tribunal
transferred by way
doesn't
of
record
mistake.
my submissions with regard to the points I've taken in my application, it's not, it cannot be held against me, my lord. It's a property I have purchased, I have paid
I
my dues.
appreciate that, but I'm asking you, show me that you have raised this point.
I
before the
can show
tribunal.
it from my application only, my lord.
Application, sir. You
Yes.
may have taken many points, but you may choose to raise 1 or 2 points from that
No,
at the time of.
I have taken every point, but if
When the
DRT
law is otherwise, you have to approach that forum saying that I have raised this point, you have not recorded that.
DRT says, what the DRT order says, since you have not raised any allegation against the financial creditor of fraud, it cannot vitiate the SARFAESI proceeding. It absolutely has to be obtained by fraud because my section 3 says an encumber was
So
created.
these points has it been raised at the time of
Yes.
hearing?
Yes,
Show me not from that document, show me from the impugned order.
my lord, kindly seize the impugned order.
Yes. Show me you have raised this point.
Certified copy, my lord, will find, my lord.
Yes.
Oh, the second volume. My lord, the
The
volume,
building number was different. This
Yes.
by mistake, second floor flat was sold as first floor flat. These were returned. Show me those.
my lord, kindly seize the appellate court order is
Yes,
rather,
yes, appellate tribunal's order, yes.
no, my case is recorded after that. It starts from para 8.
Yes.
With my submission under counsel for the appellant to submit that agreement for sale was such and such. I
Yes.
argued on the point of section 47 of the Registration Act,
Yes.
whether it will take effect from agreement for sale or not. In the second schedule, details of the property are mentioned as premises number 102 by 76, presently 102. The 102 record, 102B, B it would have been. Yet-
Nothing has been stated with regard to
Submitted
this
the-
dispute.
Hello?
What you are saying, 102 by 76, 76B, nothing
They
has
have
been recorded.
admitted in their opposition.
Your only point was section 47 of the Registration Act.
Yes,
That was you have
No, that-
raised.
other than that, subsequently, my lord,
This was
responding.
the law point which you have raised. It has been decided. No points on fact you have
Lord,
raised.
if I take my points in my plaint, if the court, I can go before, if today I file a suit,
Sir, what is the law, sir?
sir, my lord,
If some points you have raised not recorded, what you have to do?
but my lord, make
I
it,
think AIR 82 Supreme Court or 81
it's
Supreme
there,
Court.
but my lord, the court has to
If it is
consider.
there, you are aware of that, please avail of those recourses. Please. I cannot go into that.
The plaint has to be.
I have to go by the points raised. I cannot go into
But
that.
I can go as, my lord, can grant me liberty, I'll go for the DRAT again, but at the meantime, this is the order passed by. The order touch-
Nothing.
No, my lord, kindly see. This is the order, my lord. This is the order, recent order passed by the, that court CJM under application on section 14. If my possession goes, no protection.
You can approach the DRT for this if you want to challenge this order.
I had, no, the parent order has been challenged. The
Yes.
parent order, in the
Then
meantime,
I have application stating this fact.
my lord,
I'll
grants me
challenge this.
liberty for a limited period.
No.
No, otherwise, my lord, I'll be put in out of possession. My lord kindly appreciates, I've purchased. I have
The
paid
forums have refused the prayer for injunction
for DRT.
and the
The DRT
points which you have raised. I'm not.
My lord, my application states all the points, my lord. I can't go beyond it, but I can go through it, my lord. It's my app.
Sir, what is the law I'm asking you?
I can rely any point I've taken on the plaint, my lord.
But the letters assume that you have taken 10 points. But you have raised in the application, you have raised only 2 points at the time of final hearing.
At the time,
And then you will go before the superior forum saying, yes, there are 10 points. Court ought to have considered 10 points.
even in
Is
second,
it the law?
even in second appeal, my lord, I cannot take a point which is beyond my plaint, but I can take a point which was raised by me in the first instance.
Sir, you are not understanding.
My lord, I understand. I bow down, but that's too much. I understand. That's
So if you understand, you go back
I really appreciate.
or you have to make arguments on the points you have raised.
Grants me
But not trying to take out a new point
No.
after finding this 47 maybe
my lord,
may not be able to
my lord, may I,
come across section 47 of the Registration Act.
my lord, before finishing, my lord, may I?
Section 54, what I was seeing when you placed section 3, I went directly to section 54. Now I find
But
the
section-
order of the appellate tribunal is on
but
54.
section-
So now you found,
But section
those-
3, I can
so you are
take.
trying to rely upon some other factual points which you did not raise.
Section 3, I can take before law point, my lord, I can take.
Yes, I'm not against you. Section 3, you can. But section 54 says that is there. Even knowledge, your right does not create any interest in
No,
the
sir.
property. So there was no embargo to transfer that.
Right. But the embargo.
The observations, I can make those observations, or if you want to go back, I can give you liberty.
By making those observations, my lord.
What?
These section 3 observations.
Section 3. Then I will dispose of this matter.
May I?
Not piecemeal observation. I will consider
Very well, my lord. I'll go back.
but I will consider all your.
But I'll go back. Before going, my lord, may I refer to your lordship only page 156 for once, my lord, for my own satisfaction.
Yes.
Second volume, page 156.
Yes.
Para H. It is the affidavit in opposition filed by the financial creditor. I state
156.
156 page number.
Yes. Page, paragraph.
Paragraph H.
Yes.
I state that a bare perusal of the application will make it evident that the applicant is a owner of a completely different flat, which is about 500 square feet, although the same may be situated in the same building. If this is their standpoint,
Whose stand is it?
this is affidavit in opposition filed by the financial creditor.
Yes.
My lord, kindly see page 153.
Raise all these points in the review that you have raised all these points at the time of hearing. It was not.
If this is just
You have a
I
very
can-
good chance of success in the review before the tribunal.
but my lord, limited 7 days. I'll go before. Within 7 days, I'll go. My lord, kindly grants me 7. If
No, no.
if I'm out of possession, there will be no. My lord, 7 days. I'm praying. I'll go before the DRT immediately. Tomorrow I'll file.
Yes.
7 days, my lord, kindly grants.
This judgment was passed in 3rd of October 2024.
There's a chance of settlement. There's a chance of settlement.
Today we are in March,
My lord,
end
7
of March.
only 7
Nothing
days.
happened.
My lord puts me on cost 7 days.
This is also one of the ground for it not passing any
I
limited.
understand. I understand.
If you insist, I will record that also.
No, my lord, 7 days only praying.
Sir, if you are insisting, I will have to
My
record.
lord, my lord.
After some argument, the learned advocate appearing for the petitioner prays for leave to withdraw this application with liberty to approach the debts recovery appellate tribunal with an appropriate application. To stop, in the light of such submission, CO such and such stands dismissed as withdrawn with liberty to the petitioner to approach the debts recovery
I am for the petitioner.
Yes.
But I am for the defendant before the learned court below. It's a partition suit preferred by the opposite party plaintiff, my lord. I entered my application.
What is the impugned order?
Impugned order, my lord. My
Partition
application,
suit, you are the defendant.
my lord.
Yes, what happened?
Evidence is going on, my lord. I prayed for issuing summon for calling for a witness, my lord. The order dated 20th of February 25 is the impugned order, my lord. I prefer,
Witness named in the list of witness.
my lord.
Witness named in the list of witness. Yes.
It is reflected in the order itself also, my lord.
Yes.
I preferred an application under Order 16 Rule 10(3) for issuing bailable warrant against the particular witness.
For proving what?
My lord, the deed which I have exhibited, the witness is the
How that
attesting-
witness is related to the deed?
He is the attesting witness there, my lord. The father of the petitioner,
Father of the
the portion of
the particular witness whom you want to summon.
my lord,
He is a witness to that deed.
my lord.
Show me that deed.
Deed is no, my lord. The father of the I stand corrected, my lord. The father of the witness is the purchaser.
Father of the witness is a purchaser.
My lord.
So how is relevant to prove the deed?
But he is in possession, my lord.
So for the purpose of proving the deed, you said he is a relevant witness.
My lord.
His father was a witness. He was not a witness.
Father purchased, my lord.
So He was the purchaser,
my lord.
not a witness.
No, my lord.
So what did the trial court say?
My lord, the impugned order is wrong, my lord. The witness recorded in the name of Sopan Burman. But
Yes.
but he is not the witness, my lord, whom I asked for issuing summon, my lord. He is German Burman, my lord. Kindly see my
He is,
kindly see my application at page
it's the
72,
wrong
my lord.
recording.
My lord, wrong recording, my lord.
Show me from your application whom you wanted to summon.
It is at page 72, my lord. My application. First, second, third. Fourth line, my lord. সাক্ষী শ্রী জার্মান বর্মন ওরফে জার্মান রায়, পিতা স্বর্গীয় কাশীনাথ বর্মন।
How many witnesses have deposed on your favor?
4 witnesses already
What are the
deposed.
names of those 4 witnesses?
The defendant number 1, defendant number 2, my lord. The plaintiff,
What are the names?
petitioner number 1 and 2 hearing.
German
has not deposed, my lord.
So for what purpose? He was a witness.
My lord. My evidence has been closed and the learned court below was pleased to fix date for argument.
Do you have a copy of this deed of number 2420?
My lord, at present, I don't have. I can produce before your lordship. Order dated 12th of September 2024 reflects the.
No, you have
witness to
not
be
filed
summoned.
the list of witness. This is the recording of the learned trial judge.
Well, it
Show
is
me the list of witness. Show me the list of
Lord,
witness.
order dated 12th of September 2024.
Order dated 12th of
September 2024. It is reflected. The schedule has been fixed for recording evidence of the witnesses.
Yes. So Putin, Bourbon and German Rai
My
was
lord.
on 24th of September.
My lord. Putin Burman has been examined, my lord. German Roy alias German Burman. On 24th, 26th, my lord, for Gaur Burman and Nitai Burman. 27th for Batasu Burman and 30th September for Bimal Roy and Nokul Burman.
It has been submitted by the learned advocate for the petitioner that the petitioner paid for issuance of witness summons upon one German Roy, Jarma in German Roy as DW4.
Alias German Burman.
Yes. You have said German Roy.
My lord.
This person you want German Roy.
Alias German Burman.
There is no alias here in the witness. You are trying to confuse. German Roy is there. I will.
It is reflected.
German Roy as DW4. Full stop. কি বললাম? As DW4. But the learned trial judge rejected. Now, the learned trial judge closed the evidence of the defendant on the ground that Sopon Bormon is not a material witness in the said case. The learned advocate further submits that the petitioner did not pray for citing Sopon Bormon as a witness for the defendant. Full stop. Paragraph petitioner is directed to serve a copy of this application by registered post with acknowledgement due and file an affidavit of service on the next day. What happened on 18th of March?
My lord, the date fixed on 29th for argument.
29th of
20th
March.
of March,
Uh, by registered post with acknowledgement due and file an affidavit of service on the next date. First up, from the order imputed, it appears that the 18th of March 2025 was fixed for argument. First up, the learned advocate appearing for the petitioner submits that the next date for argument has been fixed on 29th of March 2025. First up, there shall be an order of stay of all further proceedings in partition suit 37 of 2018 pending before the learned civil judge senior division first court at Malda till the end of April 2025 or until further orders, whichever is earlier. List this matter under the heading motion in the monthly list of April 2025. Yes, next.
But the petitioner before lordship is the plain.
Not a good case. So Raut, your face shows something.
My face.
Face.
Was.
Reading of your face shows that you do not have, might not have a very strong case.
Forget about the geography of my face.
He's too a gentleman.
For the timing, let us forget. My lord, petitioner before lordship is the plaintiff in a suit for party, suit for declaration that have acquired substantial right over the property by adverse possession. But it is a club.
Taking the aid of the Supreme Court judgment that as a plaintiff, not as a shield, but as a sword also.
Yes, yes. Now my lord,
what happened thereafter?
My filed a suit, injunction application, trial court refused.
Appeal court refused.
Refused. My lord, on the ground, yeah, I'm coming to it. I'm coming to that.
Contested. Or ad interim.
Contested. My lord, sufficient. My lord, unimpeachable.
Raut, I am expediting the suit.
My lord, for the time, your lordship kindly consider. 2007, uninterruptedly, I have been doing the variety, the society, the lot of philanthropy.
Club.
My lord. Registered under the society registration act. I am getting.
You are performing Durga Puja every year.
Not only Durga Puja,
all cultural functions also.
And I am getting the financial assistance from the government.
Yes, yes.
I am getting financial assistance.
With the help of that, you are performing.
So my status, my lord, that cannot be thrown out right now.
That gives you a status in the immovable property, Mr. Raut.
My lord.
Aid from the government for performing gives you a right in respect of an immovable property.
My lord, rightly, your lordship kindly allow me to make some
2007. Registered in 2007.
My lord, with the permission of the then erstwhile owner.
Show me your registration certificate of 2007.
My lord, 7, your lordship. My lord, your lordship kindly come to the annexure 1 to my page, my lord. Although my lord, the date has not been mentioned, page 38.
Page 38.
My lord.
No. This is to officer in charge. Show me your registration certificate.
Next, my lord, next.
39.
My lord.
2013, Mr. Raut.
My lord, 2013, but my lord, registration was done 2013. But your lord, my lord.
So not on 2007.
My lord, for the timing, let us forget about this. My lord,
and suit filed in
2000,
So 2013, 12 years will be in 2025. So prior suit,
My lord,
not 12 years did not expire from
my lord,
2013.
for the timing, well, let us forget out the status of my lord, the acquisition of right by adverse possession. But my position, which is lawful position, and
Show me the document of your possession.
well, a series of documents I filed, government aid and all these things.
Government aid does not give you possession.
And my lord, the erstwhile,
Government aid, Mr. Raut, their possession is declared and that is a document of possession.
but
Mr.
not,
Raut.
not,
Show me a
not,
valid document of possession in respect of your property standing in your own name.
my first document is page number 38. The erstwhile
38 is a letter to the officer in charge.
no, my lord, by that letter I was allowed to use and occupy. Your lordship kindly consider. Erstwhile owner intimated the concern of his
Mr. Raut, do you know how the permission for holding Durga Puja is granted? So, you know very well. Yes.
That is known to all of us.
So, application, look, Durga Puja, Kali Puja are not being allowed to perform. Please grant me permission.
Electricity. Since long I have been enjoying electricity through the
Electricity does not give you a right.
right of
Says
possession.
Even a trespasser, the law is even a trespasser is entitled. But trespasser has to prove something more to convert it to adverse possession.
So far my position is concerned, let us for the time being, let us forget about the actual the acquisition of rights.
Since it's a contested hearing, what documents they have produced? What is their claim?
Only the deed of sale. They purchased the property in
That is only.
And that too in the year 2000.
And that is
2020 they have purchased.
And
prior to that, so many earlier past owners, they transferred their rights.
So by virtue of a deed of conveyance, no right flowed to them,
No
but
doubt.
right flowed through government aid
No
in
doubt.
your favor.
No doubt. By virtue of
Mr. Raut, I am expediting the suit.
in the meantime, kindly protect.
What? If you are in possession, you are in possession. If you are not in possession,
They are going to
both courts. Mr. Raut, if you are in possession, you remain in possession. And if in the evidence you prove that you are in possession, if they have not paid for recovery of possession,
not yet. No counterclaim, nothing. No counterclaim, nothing of this sort. Nothing.
So your suit will be decreed. If you prove adverse possession, they will be restrained from entering into your property.
In the meantime, if my client is ousted forcibly, I'll kindly protect from that. Kindly protect that. Up to the passing of the decree or final adjudication of the suit. Kindly protect that. I am in my position, even as it appeared from the voluminous document. I am in position.
Mr. Raut, your client has sufficient means to protect possession.
No, my lord, no.
Considering the status of your client,
All the club members are nowadays not, my lord, there.
has sufficient means to protect the possession. You don't need the help of the court, order of the court to protect your possession.
Is there positive apprehension at any time, my lord? Or they are the promoter, they have purchased the property. And they are trying
Promoters, Mr. Raut, cannot do anything without the help of the local club. Cannot. More so. So, they will come to you.
What I am saying, subject to your lordship. Let this should be expedited, no doubt. But in the meantime, kindly for time being, kindly. Since I
Let me go through the order which has been passed.
My lord, my lordship, your lordship, kindly come to the relevant portion of the order. So far the trial court order, your lordship.
No, so affirmance you can place the appellate court's order.
My lord,
or which one is more elaborate?
My lord, your lordship, straightway come to me page 22, trial court's order. Only the relevant portion. Your lordship need not be troubled much over the matter. Only after discussion of recording of submission and all these things. Order 22. My lord, the page 22. Trial court's order, paragraph 1.
In whose name the record of rights stands?
But Borgadar is there. Borgadar was previously there.
Borgadar?
Yes.
You are not the Borgadar.
No, I am not.
So,
I am not the Borgadar. Malay, actually, this
you are protecting the Borgadar, Mr. Raut.
No. Malay, this is the nature of the property. It is Sali land, Sali. And somehow they have converted into Vastu. For the purpose.
Conversion also made.
Malay.
At their instance. So record of right stands in their name.
I don't know at their instance, since they have purchased the
but
property.
Record of right stands in their name.
Record of right, not yet. Not yet.
Yes, it has been recorded. Kindly come to LR record of rights.
Malay,
Duly recorded.
Malay, they have
in respect of the suit property.
only in the year December 2020 they have purchased. Thereafter, so many owners are there. They have transferred. I don't know for what reason they have transferred. One after another.
This is prima facie only. Suit, he will succeed. Mr. Raut, he will succeed in the suit. Ashok.
Kindly protect.
An order of demolition of the building.
Yes, yes, call the next matter.
That's item 15, 16, and 17. They are connected matters. They are emanating from the common order of the National Consumer Dispute Redressal Commission. My lords, there's one more petition that we need to file. We are in the process of filing the petition. My lords, there's one more petition that we need to file. Same order, my lords. It will be filed during the course of next week.
All right, you proceed with this.
My lords,
When it
I'm
will come-
being led by a senior counsel from Delhi, my lords. When the fourth petition is filed, my lords, the senior counsel will appear from Delhi and hear the matter.
The learned advocate appearing for the petitioner prays for an
Fixed for demolition. Since your lordship,
same order. Yes.
since your lordship will not take up the matter,
The number
25, my lord. There is no
25.
25. Yesterday I mentioned before your lordship was pleased to, my lord, grant liberty to file, my lord, fix it today.
Please wait, sir. Yes, yes, call the next matter.
18, my lord, I am appearing on behalf of the plaintiff petitioner, my lord. Only in this matter, there is a caveat. My lord, last 2 or 3 days, my lord, I tried to serve upon the learned advocate appearing for the caveator, my lord. My lord, he told me that now I am outside the High Court, my lord.
Who is the learned advocate?
My lord, lastly, my lord, yesterday, I sent the copy of this application through the registered court directly the opposite party, my lord. Learned advocate, Mr. Shubhram De. Yesterday, my lord, I sent the application.
Challenging an order of impounding.
Yes, my lord.
Ashun. The learned advocate appearing for the petitioner submits the Dakun, পরেরটা ডাকুন. Yes, yes.
Item number 19, my lord, I am for the petitioner praying for expeditious disposal of the execution proceeding along with
The
connected.
case pending.
Yes, lordship.
So
The-
this case has to be disposed of.
Lordship, miscase pending,
Case under what provision?
miscase under lordship,
Rule 101.
yes, lordship, 101. Lordship, I am for the petitioner filed the suit since 2013. Let's kindly give
Madam,
just
but
2
the
minutes.
case are to be heard fast.
Lordship, kindly give just 2 minutes, lordship. Lordship, the
Madam, otherwise I will have to direct him to serve.
lordship, the trial court also the file the suit, lordship.
Yes, 21. 20.
My lord, I am asking for item number 20, my lord. I am on the way, my lord.
Yes, yes.
20 and 21.
What do you want?
My lord, 20, item 20, I am paying for expeditious hearing
Of what?
Title suit.
Title suit.
Yes, my lord.
What is the stage?
Stage minus service return, but fact is that petitioner has been dispossessed from his own house by force by the opposite party.
Without service, completion of service, no.
No, my lord, only 1 point, my lord, only 1 point. My lord, it is a case under section 6 of the Specific Relief Act. The summary
So it is not to be served.
served, my lord.
You have said it is fixed for service returns.
Service return, but my lord, kindly consider it is a date given after 8 months.
How many defendants are there
Only 3. They are paying 2 times.
who have not been served? 1 and 2 has appeared.
Yes, my lord, served, I mean, they have appeared.
No, you have said service returns.
For service, but they had appeared, my lord. They had appeared in the matter. 2 times they have taken time.
This application under Article 227 of the Constitution of India is at the instance of the petitioner in a suit under Section 6 of the Specific Relief Act, praying for a direction upon the Learned Civil Judge Junior Division First Court at Barasat to dispose of title suit number 1199 of 2024 expeditiously. Full stop. In view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite parties. Full stop. The learned advocate appearing for the petitioner submits that the suit is otherwise ready for hearing. Not ready for hearing. Temporary injunction application is pending. It's from July. So it has to be hard fast. কি বললাম? ওটা কেটে দিন. Learned advocate submits that suit is otherwise ready for hearing. হ্যাঁ? না ওটা থাকবে. The learned advocate for the petitioner submits that the ওটা কেটে দিন. First up, from the order sheets appended to this application, this court finds that 28th of July 2025 has been fixed for hearing of the temporary injunction application and for filing of the written objection in the meantime. Written objection has been filed.
Not yet, my lord. 2 days.
First
They have
up, the learned advocate appearing for the petitioner submits that till date no written objection has been filed. First up, in the light of the submissions made by the learned advocate for the petitioner, CO 988 of 2025 is disposed of by requesting the learned civil judge, Junior Division First Court at Barasat to take up the hearing of the temporary injunction application on the next date fixed, if the same is otherwise ready for hearing, and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. It is made clear that if no written objection is filed on or before the next date of hearing, the learned trial judge shall be free to proceed without the written objection being filed by the opposite parties. Yes, next.
21, my lord, 21, I am for the petitioner.
21,
I am for the petitioner.
same. Expeditious hearing.
No, my lord.
Yes.
It is the petitioner. Petitioner filed an application for repairing of the dilapidated condition of a tile-shaded room. That has been rejected by the learned court.
Repairing application rejected.
Rejected on the score, my lord, if it is allowed, they will get a preferential right over the property. Equitable right. I am failed to understand.
At what stage you have filed?
At the initial stage.
What is the suit for?
Suit for declaration, revision of license. They are saying I am a licensed.
What is the stage of the suit?
I am a co-sharer.
What is the stage of the suit?
My lord, stage.
Final stage.
No, not final stage.
Then don't repair.
No, my lord, I highly
Advisable not to repair.
I am highly prejudiced, my lord, because I have already filed a
By the order including the
On behalf of the petition.
item number
22,
Yes.
I have filed this application for expeditious disposal of 2 applications, order 39 rule 4 and the question of maintainability.
order 39 rule 4 and
The question of maintainability because the suit is not maintainable against the cooperative society.
order 7 rule 11.
Question of maintainability, yes. Order 7 rule 11 and the question of maintainability. The defendant has closed
It has been fixed.
on 25th of March. On the next day, we have completed our argument. The presiding judge has been changed. The plaintiff is taking.
Argument has been concluded, Mr. Ghosh. Is it necessary?
Concluded, we have concluded. The plaintiff is taking time. We are the defendant. We will also kindly come to last.
For further hearing of the
Plaintiff, the plaintiff is taking time and the court is extending the.
what are the applications?
2 application under order 39 rule 4 for vacating the identity order of injunction past ex parte and the application for maintainability of the suit, stating that this suit is not maintainable because it is against the cooperative society. But these 2 applications fixed on 25th of March, on that date, you lost
25th of March. Mr. Ghosh, learned advocate appearing for the petitioner submit
Keep the direction to miscase expeditiously disposal, Lordship, Lordship, item number 19, Lordship, your Lordship.
Please wait. Yes. What is the next matter? Item number 23, pass over next.
My lord, this is my application. I am the defendant tenant.
Can you come at 2 p.m.?
Yes, my lord, 2 p.m.
2 p.m.
Have our lunch and come back.
2 p.m. 2 p.m.
2 p.m.
2 p.m.
No one with office.
25 minutes. Mine is 25.
24, 25, 2 p.m. Serially, তারপরেই upgraded.
Grateful.
Lordship, item number 19, Lordship. Item
My
number
lord-
19, kindly keep the direction, Lordship,
I
miscase.
gave you that opportunity, madam. You did not
Lordship,
take that.
sorry for that. Please, Lordship, kindly.
Yes, madam, without the miscase, title execution cannot be directed.
Sorry, Lord. Kindly, Lordship.
Don't allow the
Miscase.
court to pass wrong orders. You
Sorry,
ought to have
Lordship.
pointed out.
Grateful,
Come at
Lord.
2 p.m. এই অর্ডারটা একটুখানি আসবেন 2 p.m. এই লাস্ট ওনার Item number?
23.
Yes,
Perhaps
23 was called on.
My
You
lord,
are not
after-
there.
After 115, I believe, my lord, kindly.
What can be
My
done?
simple matter.
Yes,
This
yes,
is
call the
disposal,
2
my
PM.
Lordship, item number 19.
Lordship required for item number 2 today's list.
Item number 2 তে হয়ে গেল।
Lordship, item
Yes, yes,
number.
please wait, madam. Yes, call the continuing matter.
I do appear for the
Yes, yes.
opposite party plaintiffs, my lord.
Where is the petitioner?
And they have not yet arrived.
Well, there was a recalling application or 7-2 dismissed and my lord defense struck off. After 2.5 months of that order, we make an application for recalling.
For Mr.
On the ground,
I appear for the petitioner, my lord, in this matter. I mean, led by Mr. Rachit Lakhmani. I think.
Yes, yes, proceed,
Yeah,
madam.
My lord, he's already on the way.
my lord, I am the defendant tenant. My lord, 7172. Your lordship, my lord, pertaining to the same building has recently passed a judgment where my lord deposits were held to be bad deposits. Deposits made before the rent controller were being held as bad deposits during hearing of the 7-2 application, and instead of giving an opportunity to put in that money, defense was struck off. Your lordship recalls one very recently, and your lordship passed a judgment. Same building, same set of advocates, same landlord, but of course there are 60 tenants. So this is another tenant, identical facts, but for one difference. Please allow me to. But for one difference. In the facts of this case, there is a finding in the impugned order that the learned advocate appearing for the tenant made a submission that the bad deposits are admittedly bad deposits. So there is an admission. So we went back to the same court. I am not troubling your lordship, my lord, only with that order. We went back to the same court. The learned advocate on his affidavit, personal sworn affidavit, swore that this was not what he intended to say. What he intended to say was that even if assuming that the deposits are bad deposits, in 7-2 I should be given an opportunity to deposit. If the court holds that the deposits are bad, give me an opportunity. So my lord, it's the my lord, other argument that assuming that the deposits are bad, this is clarified by the junior my lord appearing in the matter before the trial court on his personal affidavit. And based on that, my lord, a recall was applied for.
Where is the application under section 7-2?
I am coming.
Where you have said that you have deposited.
Yes, I am so grateful, my lord. My lord, kindly take the application. My lord, kindly see both 7-1 and 7-2 because I have deposited under 7-1. Kindly see 7-1 first, my lord.
These are 3 months of July, August, and October.
These are good deposits. These are anyway good deposits.
These are good deposits.
Of course, I'll show that.
No, what are bad deposits?
Yeah, those are actually good deposits, but held to be admittedly bad deposits.
So July, August, and 2020 and October.
Yes.
These 3 months.
Yes.
So what is?
May I first show your lordship my lord, the receipts of these deposits? Kindly, my lord, just for a moment, take page 93, 94, and 96. My first argument is that these are
why it was held to be a bad deposit?
Because it's out of time.
So
no, it is within time. Kindly see. Kindly see for a moment. 93, 94, and 96. 93, my lord. Kindly see there, my lord, July 2022. And kindly see, my lord, the date of this is my lord of the subsequent months. Kindly see, my lord, July 2022. There, your lordship is on top.
July 2022.
Yes, and at below, my lord, left bottom. Kindly see, my lord. Kindly see within August 30th. So within the last date of the next month. So July deposit is being made within August under section 22, my lord. Unless there is a contract. In the absence of a contract, it is within the last date of the next month. Your lordship will see the act for a moment.
This is the premises tenancy act.
And there was a digitization issue. Even if I'm late, even then, my lord, I should have been given a chance to put in my money. My defense has been struck off.
बोलो 22 निकालो ना यार. Kindly see, my lord, page 22. May I place, my lord? No rent deposited with the rent controller shall be considered to have been validly deposited under section 21 unless deposited within 15 days of the time fixed by any contract in
So
writing.
it was 30th of August.
Yes.
Within time.
Yes, within time, because for July, it's, my lord, before August.
But
So now this is, my lord,
this 3 months, 93, 90.
93, 94, kindly see 94.
So all within that time.
August, no, my lord, August, again within September 27,
September.
and then, my lord, 96,
September within 7th of October.
yes, no, 96 is, my lord, October.
Sorry, 96. So
Yes.
September there is no difficulty.
No, there's no admission in the order.
October on
Is within November, my lord.
24th of November.
So, my lord, all three deposits firstly are within time. So I'm through. Number one. May I, my lord, make out my case?
Yes, how these are bad deposits?
Kindly see section 22.
Yes.
No rent deposited with the controller shall be considered to have been validly deposited under section 21 unless deposited within 15 days of the time fixed by the contracting writing for payment of the rent, or in the absence of any such contracting writing, unless deposited within the first day,
The last
day of the month following the month for which rent was payable, provided that where any rent remitted to the landlord by postal money order within the prescribed period is returned to the tenant by the postal authority as undelivered on account of
This is for the first month. This is for the first month. After that, for every month, it need not be sent by money order.
Kindly come to the first month. What has happened in the first month in June? He has shown you page 93. He should have shown you page 90. Kindly come to
Yes.
page 90. Page 90. First month there is a delay. 1 second, I have not disturbed you. Page 90, my lord. Kindly.
You have not said that when you moved. You told all the months are within time. Yes.
In the
Yes.
page 90, kindly come to the number and date of the register of the challan. Kindly see, my lord, on the left hand column. Part 2 under part 2. 15/5/2022.
Yes.
So it should be 15 days from that. That is, my lord, 30th of May.
No, April it has not been held to be invalid. It's July.
This is, my lord,
3 months is July, August and October.
admissions by the learned advocate. But, my lord, it starts from here. I'm sorry.
Let him submit.
My lord, somebody's career. Hey, I'm sorry, my lord. His career. No, of course.
Yes.
My lord, that is there. Kindly see 15/5/2022. It has been deposited on 7th June.
But this has not been held to be invalid.
Yes. Now, my lord, kindly come.
Only July, August and October. So July, August and October was within time. This was not pursuant to return by money order.
My lord, he had admitted that these are also bad.
How? If it is within time, admission can override the provisions of the statute. And who has admitted? Advocate. Binding on the client. When from the statute, he is within time.
But he has
Advocate will make an admission.
He has said that he has not taken this point, that it was by electronic and all the digitization has no point has been.
Forget about that. Not with digitization, but it is within time. If it is out of time, digitization and other things will come. This is absolutely within section time limit as per section 22.
Every month.
Yes. Don't hold conference here.
It has just been briefed.
Don't hold conference here.
I have briefed, yeah, it has been briefed. So kindly get this time. Lord,
If you are not ready, say so.
kindly may I come back to because I understand there's no point in Malad. If it's in law, it is there. What he said and what he said not, it could not be binding on. But kindly keeps it tomorrow. I'll come.
What happened tomorrow?
Monday is the matter, my lord, for evidence, my lord. My defense has been struck off because, my lord, even if
Monday is the date fixed for
Preemptory hearing.
for preemptory hearing, my lord.
Coming back tomorrow.
My lord,
Tomorrow.
We are here, my lord. It's not that if an order is passed, I will only pray for a time.
Heard the learned advocate for the petitioner. First of the learned advocate appearing for the opposite party prays for an accommodation to assist this court on the issues that has been raised. To assist this court on the issues that have been raised by the learned advocate for the petitioner in course of hearing. First up, list this matter tomorrow under the heading motion.
the advocate has put in an affidavit, my lord, before the court below that this wasn't the submission. Submission was, even if assuming that it is bad, you have to allow me to deposit.
Yes, yes. Call the next matter.
118 proceeding has been initiated by the Shantipur Municipality, my lord. Without, my lord, the order has been passed, my lord. Order has not been communicated to.
Order of what?
Order of demolition. Passed, my lord, without communicating the order, only executing order has been, my lord.
Order passed by the municipality.
Lordship.
You have challenged in the miscellaneous appeal 218 subsection 3.
Yes, yes.
What happened?
39(1) to reject it. Your lordship, kindly have a look to the impugned order. No order has been communicated. Demolition order has not been communicated. But the execution of the demolition order, only direction was given to that, look, we are going there and demolish the property.
Where is the order of demolition?
Order of demolition has, your lordship, kindly see the page 16.
Have you implemented the complainant?
No, my lord, the complainant, my lord, in appeal, misappeal and complainant was implemented. In the trial court, my lord, complainant was not implemented.
Why?
Although, my lord,
On his basis, the writ petition and order was passed. Pursuant to that, a proceeding was initiated.
Your lordship, kindly can leave, my lord. I shall, my lord, incorporate, my lord. Otherwise, my lord.
Where is the order of demolition?
My lord, page 16, your lordship, kindly comes. In respect of order of BOC Shantipur Municipality, illegal construction of you will be demolished. Page 16, 1-6.
This is the order of demolition.
No, this is the communication that we are going to execute the order.
Where is the order?
Order has not been delivered. Your lordship, kindly see the last. My lord, I have.
Only, what have you challenged in the appeal?
No, that this notice has been challenged to the appeal because Lord, I don't have any order. Your lordship, kindly.
Appeal is not maintained. You have to challenge the order.
Your lordship,
not an order.
Your lordship, kindly see my lord, page 21. Why do I, my lord, go before any forum? There is no forum until and unless, my lord, I obtain the order. And my lord, I was handed over the order. If it is not handed over, my lord, your lordship, kindly see page 21. I applied for the order. This is my application.
No, 11th of March. The initially page 16 is of 3rd of March.
3rd of March. Your lordship, kindly see the next page 20, page 20. Annexure F. Some time was extended only to obtain the stay order from the Honorable Court.
Where?
Page 20, 20. Daughter of the petitioner, my lord, prayed before the person who has come to demolish. On her request, my lord, sometime 7 days has been extended.
No, at the time of execution of the order on 11th of March. What is the order of demolition?
Order has not been, my lord, supplied.
This application under Article 227 of the Constitution of India is directed against an order dated March 10, 2025, passed by the Learned Civil Judge Junior Division, First Court at Ranaghat in Misappeal number 1 of 2025. First up. By the order being number 2 dated 10th of March 2025, the prayer of the petitioner for ad interim injunction was refused. First up. Have you stated that no order was communicated? Which paragraph?
Yes, my lord. My lord,
It has been stated in the said application that on 11th of March 2025,
paragraph 9.
the main and agents of the which municipality?
My lord, Shantipur Municipality.
The main and agents of Shantipur municipality came to the premises of the petitioner to execute the order of demolition. Where have you stated that the order of demolition was not communicated?
Your lordship, kindly please, my lord, page 9, paragraph 9.
Paragraph 9 is you have
Applied for the certified copy. No copy.
certified copy. But no order was communicated, you have not stated that. It has been stated in this in paragraph 9 of the application that
Ground 3, my lord.
the
I-
petitioner
Ground 3, my lord, I mentioned.
grounds is a statement.
No, my lord, no, my lord,
That is
statement
stated in paragraph 9 of the said application that the petitioner applied for the certified copy of the demolition order, but till date the certified copy has not yet been handed over to the petitioner. First up, the petitioner preferred the miscellaneous appeal number 1 of 2025 challenging the order of demolition passed by the authorities of the Shantipur municipality. First up, by the order impugned, the prayer for injunction was refused and full stop. By the order impugned, the prayer for injunction, ad interim injunction was refused. By the order impugned. By the order impugned, the prayer for ad interim injunction was refused. Full stop. Since the petitioner has challenged an order of demolition under section by preferring an appeal under section 218 within bracket 3 of the West Bengal Municipal Act 1993, this court is of the considered view that unless an interim order is passed, if the order of demolition is executed in the meantime, the miscellaneous appeal will become infructuous. In view thereof, this court is of the considered view that the petitioner is entitled to an interim order. First up, there shall be an order of there shall be an ad interim order of injunction restraining the authorities of the Shantipur municipality from executing the order of demolition in respect of the premises. Where have you specified the premises? Nowhere.
Paragraph, my lord, 1.
Not in the prayer.
Not in the prayer.
Everything is vague, Mr. Boni.
No, my lord, their existing structure is, my lord.
Where injunction is to be passed in respect of which property?
Address, my lord, mentioned in the paragraph number 1, my lord.
It's coming from your Sheresta, Mr. Boni.
There is a dispute with regard to the address, my lord. You also kindly see.
Address is disputed, then no injunction.
No, you also kindly see, my lord. I have specifically.
Vague injunction cannot be passed.
No, my lord, I have specifically stated. You also kindly see. 1, paragraph 1.
No holding number, nothing.
The opposite parties have termed the aforesaid address as holding number 77 by 1.
I do not know what is 77 by 1. I am passing an injunction on 77 by 1. I do not know which premises. If you are 78 by 1, gone.
No, 77.
Kilo. Restraining from executing the order of demolition in respect of holding number 70. Holding number premises holding number paragraph 1 bole dewa ache 77 by 1 of ward number 16 of Shantipur municipality, which is not at all correct. What are you You don't know your
This is- no,
premises.
This is, no, I have mentioned my address. This is actually Siardas Road, Shantipur district, Nodia, pin 741404.
So I'm saying that.
Because, the service has been made, the writ petition was disposed of on that regard.
What? Yeah. You have been drafted more carefully. What have you done? That is the only basic thing. You have to specify the premises that you have not done. Everything vague. That is also not correct. You have said.
Kindly sees the
Holding
page,
number of the league
page 18, page 18. That is the appeal.
In respect of the property of the petitioner, as described in paragraph 1 of the civil division application, everything is vague. Order will be also vague. Till the end of April 2025 or until further orders, whichever is earlier. Motion monthly list of April 2025. Petitioner is directed. Acha, ekdom matay kore deben. On the prayer of the learned advocate on record of the petitioner, leave is granted to the on the prayer of the learned advocate for the petitioner. Advocate on record korben na. On the prayer of the learned advocate for the petitioner, leave is granted to the learned advocate on record of the petitioner to implead the complainant as a party as an opposite party in this civil division application. Let the amendment of the cause title be carried out, comma, here and now, full stop. তারপরে ওইটা তারপর হচ্ছে petitioner is directed to serve a copy. এটা মাথায় করে দেবেন আর এটা শেষে করবেন. Petitioner is directed to serve a copy of this application by registered post with acknowledgement due upon the opposite parties hearing, including the added opposite party, and to file an affidavit of service on the next date. Yes, call the next other. 19th taken.
26 mile only release. So I will instruct.
19, my lord. Lordship, only one miss case is pending. The filed by the third party along with stay application. The trial court rejected the same, being defected and directed to file a fresh stay application. But till now, the third party did not file any stay application.
What happened on 18th of March 2025?
18th of March, I have no instruction from my
That was
client,
that
Lordship.
was for awaiting order of this case number 75 of 2024.
Yes, Lordship. The opposite party is not file any stay application, Lordship.
Ashun, this application under Article 227 of the Constitution of India is at the instance of the decree holder praying for a direction upon the learned judge third bench, Presidency Small Causes Court at Calcutta in ejectment execution case number 156 of 2013 arising out of ejectment suit number 12 of 2007. Of the learned advocate appearing for the petitioner submits that Yes, Mr. Rai, what is the grave urgency?
Tomorrow is the date for delivery of judgment. On that score, your lordship is pleased to fix this matter on 17th.
You are opposing.
Yes.
Got hold of me in the corridor and said, come and oppose me.
No notice was given prior to mentioning.
Ask him.
Yes, Mr. Rai. Don't look at the back.
It was the learned. He did not inform me that he is instructed to appear in this matter. On the contrary,
That fix the rate 102, it will come in its due course.
and that's why information was given to the learned.
He knows that I am appearing, he catches hold of me in the corridor.
Oh.
He says it's not on notice.
Yes, yes, what is this matter?
My application on order 40 rule 27 was rejected along with argument was closed and fixed for delivery of judgment because the senior advocate was engaged, could not appear on the date of hearing. It was late. Filed application.
Argument closed. You have advanced your arguments.
Fixed for hearing on the law points. That is the order. My lord, if you lordship kindly turn to the order itself.
No. Which order?
21st February 2025.
Application was ordered in 3 parts. Was not heard.
When did you file the application under order 41 rule 27?
That was filed on 12 2nd 2025. Order number 28, my lord will find.
So when it was fixed for argument?
Yes.
Malafide. Malafide.
There is a dispute regarding the which sect is
Maybe. You ought to have filed this application earlier.
the documents which have
Mr.
received.
Rai, you are well aware of the proposition of law. This application has to be heard along with the appeal.
Appeal.
So you have filed after the party have advanced their argument. Thereafter, you have filed on a date.
No, it was filed on 12th.
Yes. Prior to that, arguments were advanced. And this is an appeal of 2022. What were we doing?
If your lordship can consider that the earlier date 6/2/2025.
If you
That
want,
will delay.
if you want, you will be only permitted to advance your argument. So Raj, this is absolutely a malafide application. Only to delay. What is the decree for? You are
Partition.
Preliminary.
In a moment, whether if it proves that he belongs to a Shia sect, then I'll get the proper entity.
you advance your argument, but the only difficulty, Mr. Rai, is
Documentary evidence which was there, my lord, it could not be as it were, my lord. I cannot improve anything to that extent to when I got the documents and when I filed the same. That if I can satisfy your lordship from here and now, whether there is any malafide on my part to produce the same, my lord can you consider the order
you also did not move
that,
that application.
that is fixed for hearing of order 40 rule 27 and the argument of law point. I engage a senior advocate.
I appreciate. Senior advocate will give reply on the law points. So, Mr. Rai, so that was your prayer. So, you will be giving your final reply to the points of law.
And also for hearing of order 40 rule 27. Both are fixed.
That was not your prayer. On the ground of the senior advocate to give reply to the law points, but not for moving the application.
No, subject to question, my lord, if you lordship can turn to the order dated 21st February 2025.
Yes, I am at that.
Interval closed and hearing of petition of order 40 rule 27. My lord, got it?
Where?
At the top, order number 28 dated 21st February 2025. At the top, my lord will find.
Yes.
Yes. So, order 40 rule 27 rejected along with closing by. As done.
This happens when a senior lawyer from a high court is engaged
Yes, my lord.
to appear and argue in a title appeal
Thank-
at Alipur court.
Thanks to God, my lord. I am not the senior advocate, so I am relieved in this.
Senior counsel, I said.
Senior counsel was engaged in this courtroom number 6.
I am, as far as I know, I am the senior counsel. Because it may, my lord, can you consider what are the documents and when I get it. This is the only thing, my lord, I will draw your lord's attention.
Yes, Mr. Mukherjee.
Only I am
My
paying
lord, kindly
any
cease-
cost, anything, my lord, I am not.
kindly cease his application
Hey, Baba,
at page 31.
31, yes. Yes.
Not a whisper.
Of what?
Why this is coming so late at such belated stage? And secondly, these documents are already produced in the trial court.
No.
Lordship kindly sees this document. No whisper of this document.
No, these are produced marked as an exhibit.
Marked as a X for identification. He could not prove these documents. I'm showing.
It's 35. I've annexed all those documents.
No, but Mr. Mukherjee accepting that, can an application under Order 41, Rule 27 be decided in isolation with the hearing of the appeal?
He did not move.
Then it will dismiss.
His
It
appeal
cannot be rejected.
Can be dismissed. This is Order 41, Rule 27B. Kindly take up Order 41, Rule 27B.
If courts is of the opinion.
Lordship kindly.
It's the court's requirement. It's the court's requirement.
It's court's requirement.
So if it is so, can it be rejected prior to the hearing of the appeal?
Lordship kindly sees this.
Yes.
Yes, Mr. Rai, where is that judgment? You have not brought the judgment.
In the trial court, what he has done.
It cannot be heard in isolation of the appeal, Master.
Where is that? Mr. Mukherjee is disputing that proposition.
Dispute করছো?
My lord kindly says the document he sought to produce.
Order 41, Rule 27B.
No, my lord. Document what he sought to produce, he has stated in the trial court that original passport has been deposited with the authority concerned and the receipt whereof has been destroyed permanently, which is on my custody as on this date. And thereafter, the learned trial court has passed the order, allowed him on recall, allowed this document on recall, trial court, and passed this order. This was marked X for identification. What is he trying to bring afresh now? I'm sorry, my lord, I've got only one copy.
This is that document.
Yes, kindly seize.
Mr. Rai, if you want to advance your argument on the law points,
Same
An
document,
opportunity
same
can be-
application.
can be given.
Depends of respect to my land friend. I can turn to page 35.
35.
Which,
Yes.
to whom it was addressed and because the dispute regarding the sect of the particular community. To Akbar Ali. Who is Akbar Ali? The predecessor of the defendant. For which he has. This is no objection to the Shia Muslims matam. Possession being.
This is a document of
Yes,
1965.
it was subsequently minor because it is a dispute.
When you have found out that
It is there in the trial court.
it was in the trial court, you did not take any steps to
এটা আমার
prove that.
statement ছিল।
Same document. It is here.
কোন-
It is here, marked X. Kindly seize.
কি বলছেন আপনারা? Sorry, my lord. Only for the purpose of making law point.
But Mr. Rai, only difficulty হবে নাকি একটা কাগজে? মিস্টার দত্ত, ক্যান ইউ পুট ইট ইন আ পিস অফ পেপার দিস? একটা কাগজে, প্লিজ পুট ইট ইন আ পিস অফ পেপার। ইয়েস। আর 2 PM আছে কিছু? ইয়েস, কল ইট।
Upgraded motion.
For the opposite party, my lord. My lord, many occasions the matter appeared, my lord. Time, my lord, sought for on behalf of the petitioner, my lord. This is, my lord, non-compliance of the order passed in 7-2.
Petitioner is not appearing.
No, my lord, previously it was appeared, my lord, they short time, my lord. And this is non-compliance of the order of 7-2, my lord. Thereafter, one application for modification was filed, my lord, on the self-same ground, my lord. My lord, admittedly, my lord, they failed to pay, my lord, rent for the period of, my lord, May 2019 to March 21.
This matter was mentioned
by the petitioner.
This matter was mentioned by the petitioner.
Lord, I beg to appear for the creditor opposite party number 1.
The judgment debtor in the suit for specific performance of contract is the petitioner before your lordship. But the
Section 47.
It's not really section 47. A non-maintainable petition is being filed. My lord, page 43 of my lord's brief is on the ground of limitation. The initial suit, my lord.
Limitation of what?
In filing the execution case. What happened? My lord, the initial suit, my lord, is decreed sometime in 1989. In 1990, they have filed, my lord, the execution case within time. But, my lord, as per, my lord, their written objection to this maintainability petition, thereafter, my lord, I filed a separate suit, Order 9, Rule 13. So record got misplaced. And thereafter, that execution gets dismissed. So they, after, my lord, a lapse of almost, my lord, 15 years, my lord, in 2014, took out a fresh execution case, which according to me is barred, my lord, as per Article 136 of the Limitation Act. I shall show, my lord, rather rely upon their pleading in the written objection against my maintainability petition. But the learned judge found that it's a court mistake, record may be misplaced. So this cannot be a ground by virtue of which I can hold that it's barred by limitation.
Where is it was dismissed for default?
My lord, kindly takes up their written objection. It starts with page 44 of my lord's brief, paragraph 5. My lord, entirety of the paragraph 5, your lordship need not. If your lordship takes up page 45, has your lordship got it? My lord, page 40.
Yes.
My lord, 5 line from the top, your lordship will get.
Where is your maintainability application?
My lord, maintainability application just prior to that, page 43. Yes.
Place that.
Yes, my lord. দরখাস্তকারী দেনদার পক্ষ বিনীত নিবেদন এই যে এই দেনদার পক্ষ ইতিপূর্বে ডিগ্রিদারের পক্ষে দাখিলি জারি মোকদ্দমার কতক কারণে এক্সিকিউটেবল নহে মর্মে প্রার্থনা করিয়া গত ইংরেজি সাচ এন্ড সাচ তারিখে দেওয়ানি কার্যবিধি আইনের 47 নম্বর ধারা মতে দরখাস্ত দায়ের করিয়াছেন। বর্তমানে ডিগ্রিদার অপরপক্ষে দাখিলি সত্ত্বজারি মোকদ্দমার দরখাস্ত দুষ্টে প্রতীয়মান হইতেছে যে মূল 64/88 নম্বর মোকদ্দমা গত ইংরেজি 8/3/1989 তারিখে নিষ্পত্তি হইলেও বর্তমান জারি মোকদ্দমা তামাদি অনুযায়ী 12 বৎসরের বহু পরে গত ইংরেজি 14 সালের 22/2004 তারিখে দায়ের করা। দিস ইজ দি নাম্বার, দিস ইজ ফাইলড ইন 2014 ইটসেলফ। সেই কারণে 3/14 সত্ত্বজারি মোকদ্দমা টাইম বার্ড হয় তাহা মেনটেনেবল তথা এক্সিকিউটেবল নয়। This is the sum and substance of my application. May I rely upon their pleading at page 45 in the opposition, in the written objection, paragraph 5 continuation.
You have to bank on your application for maintainability.
But they have themselves stated that it has got dismissed.
Records were misplaced, Mr.
If the record, this can be, there are provision for reconstitution. Whether that gives them a right to file a fresh execution, subject to correction, there are certain procedure, your lordship knows.
If it is reconstructed,
then it has to be on the, it can be, by virtue of an application, it can be reconstructed, it will carry with the same number. But in 2014, kindly consider, in 1990, the application, the execution case was levied. It was proceeded, their case
this was an ex parte decree.
But the court has to, yes, ex parte decree.
Order 9 Rule 13?
Yes. Everything I lost, I am not on that. But kindly consider, one thing, whether the court do have a jurisdiction to go into, this court has not gone into those aspects. It is the contention of mine, it has time bar. They themselves stated that record misplaced, and
court has also found record was misplaced.
That is without no document. Nothing is being relied upon. On the contrary, they said that they are that.
Mr. Mukherjee, court himself observed that the records were misplaced.
But the law will take its own course.
Whether the records were misplaced or not.
This is not 12 years.
Successfully, you have dragged this.
It's not about, I have filed a separate suit. If that be so, order 9.
Proceed with that suit. Nobody is stopping with you.
That is appeal is pending, but that is other thing. But their right to file a fresh execution, Article 136 is staring at their face. Kindly see once. Whether
when your execution case files will be lost, you will understand. Then you will understand.
I am not arguing that they are remediless. Their remedy lies elsewhere. I am not saying for a moment.
Not remediless. Let it continue.
But that has to, records has to be as per the law.
Yes.
Otherwise, this will give a window. Kindly consider, this will open a floodgate. There are provisions.
No, I will stop the flood. Some bath will be erected. I will stop the flood. You need not be worried about the flood situation.
No,
those will be constructed to control flood. Those will be there.
But the court's observation with
Article 136, yes.
136 says 12 years is the yardstick.
Yes, yes.
But today, what?
No dispute on that.
Your lordship knows it's a tabular statement which is being filed. I have preferred an application. Their objection is without relying upon any records whatsoever. So the court do not have the records of that execution case in his hand. It is not a case. Even the same predecessor in chair is not taking up the matter who do have a personal knowledge. But without consulting anything, whether the court can come to a conclusion that yes, 20, they themselves stated in their objection, it got dismissed. But the learned judge recorded as if the record was misplaced, and for that reason, they have compelled to file a fresh execution. When they are written objection, they have specifically stated that দীর্ঘদিন misplaced থাকার কারণে উক্ত পক্ষের দুর্ভাগ্যবশত 4/90 title execution মোকদ্দমা খারিজ হইয়া যায়. If this is his statement in the written objection, can the learned judge, without even venturing on that issue, come to a conclusion that yes, this can be done?
Anything more? Thank you. Ashok, this application under Article 227 of the Constitution of India is Yes, next. Call the next matter.
Item number 53, madam, just before this matter. 53. It is dismissed for default, madam.
You are not there.
Kindly recall, my
At
lord.
the time
Just
of
finished the
mentioning,
number 26,
you are very vigilant.
my lord. Kindly consider, my lord, recall the order, my
Call
lord.
your other side. Bring your other side.
I have intimated, my lord.
Bring him. Intimation will not
I am
do.
coming.
Yes, yes. Who is appearing?
My lord. For item number 55, I am appearing on behalf of the
This
petition.
matter was mentioned citing urgency. This matter.
Your Honor. For item number 55.
You did not respond.
I respond, but somehow the system is not working.
Yes, it's in 55. Yes, move your matter.
Yes,
Yes.
Lordship. May please, your Lordship.
Yes.
For item number 55, I am for the petitioner.
Yes.
Here, the petitioner is a defendant in the London court below. The fact of the matter is, the plaintiff filed a ejectment suit, being number 7019/2020.
What is the impugned order?
The impugned order by which there is a 7-3 application filed by the plaintiff, and the 7-3 application has been allowed in spite of learned court will observing that in spite of having the opportunity, the defendant failed to file the areas of rent second time. Actually, what happened, your lordship, just bear with me, just 1 minute, that sometimes in 2021, it come to a knowledge of your petitioner, the sum of the challan has been not been deposited. 7-1 application, 7-2 application has been filed, and that has been allowed, and thereafter, defendant started depositing rent month by month before the learned court below. But in times of 2021, it appears that some of the challans has been not been deposited by the advocate's clerk. Then the new advocate was appointed, and upon appointment, the new advocate immediately filed an application under 151 for deposit areas of rent along with subsequent month's rent, and that application was allowed. Kindly come to page number 28, annexure P4.
Page number 28.
Annexure P4.
Yes.
That is order dated 7/7/2022. By that application, my application was allowed, and I was permitted to deposit areas of rent along with the subsequent month rent.
Yes.
And thereafter, I started depositing rent, and all of a sudden, the plaintiff at 10th of January 2023 filed an application under 7-3. I have due, that is page number 30.
Yes.
Annexure P6. And I have duly filed a written objection against that application, that is annexure P7, running page number 33.
Yes.
And upon hearing by an order dated 12th of March 2024, that petition was allowed. Kindly
Which
come to
petition was allowed?
That 7-3 application.
Give me a minute.
Yes, sir.
Yes.
On that day, when the application was taken up for hearing, that is 7-3 application, I personally fall ill. That's why I could not make to the learned court below. That's why I sent my learned colleague to attend the hearing and took an adjournment on my ground. But learned court observed, and that's why on that learned court on that date before the learned court below, I couldn't file all the deposited challan after the order dated 7th of July 2022. Kindly come to the last portion, last page of the order on that is passed on 12th of March 2024.
Yes.
Learned could observe that in the present suit, that the last line before the order started, in the present suit, the defendant has defaulted in payment of arrears of rent second time, even after the court permitted him to deposit at his own risk. That is not true. I have already deposited because of I am falling sick. That's why on the very next day, I filed an application under section 151 for recalling application. That is my recalling application is running page number 40. And upon hearing on my recalling application on that day, that is the order impugned actual, that is 5th of June 2024.
What is the period of default you have stated in 151?
Just give me a minute. 151 period of default is total 54 months. That is my
Where have you stated?
In my 151 application.
Show me which paragraph.
Yes. 151 application. Paragraph number 8. Paragraph number 8 of my this application, revisional application. And that is also
Not stated which month, nothing. For the subsequent month in the present suit. Everything
that is also there in running page annexure P3, 151 application which has been filed before the learned court below, which is running page.
Have stated which month?
Yes, in running page number 25.
Yes.
And that is my 151 application. And in that application, paragraph number 8.
Page 26.
Page 26.
When the order under section 7.2 was passed?
Order under 7.2 was passed on 25th of August 2015.
Then after that, you have defaulted by in compliance of 7.1c.
Yes, Your Lordship. In compliance of the
sir. Cannot be extended.
In compliance of the 7.2 order, I have started depositing the rent, but all of a sudden, sometimes in the year of 2018, when I started depositing with the learned advocate's clerk, that advocate clerk misplaced that entire money. That's
Cannot be helped. Sir, you sue the learned advocate's clerk, but cannot be condoned.
But this is not my fault.
I appreciate that. It's not your fault.
But for the fault of
against him, but cannot be helped.
But kindly come to the learned court's finding when the 7.3 order has been disposed of.
There is no scope to extend. There is no scope to extend. 7.1c does not require filing of any application.
But for that, the plaintiff has not preferred any revisional application.
Sir, 7.3 is automatic. Need not file any application either.
Your Lordship, kindly consider that learned court below has already allowed me to deposit the rent to
but even then you did not deposit.
I have already deposited. That is my case. I have already deposited.
could not have been granted also.
No.
At his own risk. Deposit at his own risk.
Deposit at my own risk. I
So,
admit that.
so if you have deposited, own risk goes, but you will not get any
But
benefit for that.
But 7.3 application.
Own
But
risk. It's your own risk.
Lordship kindly appreciate that if you Lordship kindly go through the order impugned, that is 7.3 order, that the last bottom portion, because of that in spite of having that second chance, I didn't deposit the rent, but that is not the true. I have already deposited, but due to my illness, I could not be present before the learned court below, and that challan had not been submitted. But on the very next day, I have duly filed 151 application for recalling that 7.3 application and filed all the challans, which has been duly appreciated by the learned court below by his order dated 5th of June 2024. That is the order impugned. In spite of acknowledging that in spite of having the second time all the challans have been deposited, in spite of that, learned court observed that the last portion order that order dated, may read your lordship, order dated 7/7/2022 passed by the, even if the challan file would have been available to the court on 12th of March 2024, showing that the defendant has complied the order dated 7/7/2022, then also the fate of the petition under section 7.3 of the WPT Act would not be changed. I have never defaulted, but after change of brief, new advocate came to the finding that all the challans were not there. On my own, I made an application under section 151 on 7/7/2022 before the learned court below for deposit all the areas of rent along with the subsequent.
The learned advocate, when the 7.3 application was heard out, you were represented.
No. On that day, on 7.3 application, on that very day, I personally fall sick. That's why I could not be there. I have sent some of my junior colleagues to attend the court and ask for an accommodation on my health issue. But on that day, he could not properly brief and he asked for an adjournment on the ground of defendant. And that thing was reflected in both the order dated.
Where is the order dated 7th of July 2022?
7th of July 2022, your lordship will find page number 28, annexure P4. Also page number 29, annexure P5. My evidence has been closed. I could not have the opportunity to cross-examine the PW1.
So according to you, you complied with the order dated 7th of July 2022.
Exactly. Yes, lordship. I have already complied with the earlier order.
Anything more?
Your lordship, I have already complied with the.
I accept your submission that you have complied with 7th of July.
I have also complied with the earlier order, also 7-2 order. But
Yes. But admittedly, there was a default from January 2018 to June 2022.
on
That
my
is not
own,
disputed.
that is not also disputed.
Yes.
On my own, I made an application.
Yes.
On my own, I made
Yes.
an application.
And prior to that, the plaintiff did not file any 7-3.
No.
Anything more? Thank
No,
you.
Your Lordship.
Ashu, this application under Article 227 of the Constitution.
I'm so grateful. কোথায় আছিস? আরে অর্ডারটা দেখতে পাচ্ছি না তো, ডিকটেশন দিয়ে যাচ্ছে, একটু শুনতে পারবি?
বলছি এক মিনিট।
Yes, Mr. Doctor.
Application for custody of the child under guardians of children.
The instruction not to appear with the wife.
And
You've got a copy.
Yes, my lord.
and
Who
wife,
are you?
husband, husband's innocuous
Not husband, father.
father. Sorry, I apologize. Well, the father's innocuous prayer that the son be admitted to an English medium school in the town of Bahrampur.
In
The town of Bahrampur.
Bahrampur.
Not English medium, my lord. International school.
Whatever may be.
Medium, because he's anyway studying.
Where he or she?
But,
He.
Where he is studying? In which class?
Class 8. Sorry, my lord.
Presently,
8 is 8.
Presently is in
Mr.
8.
Doctor,
Kindly
he's
see the
studying
order.
Bengali medium.
Yes, my lord. Kindly see the
Doctor,
order.
it will be difficult. If up to class 8, your child has studied in Bengali medium, shifting him to a English medium will not be beneficial for the child. Mr. Doctor, you are the father, you have to appreciate this. Because all along, he studied in Bengali medium.
I can even get him admitted to Ramakrishna Mission if he permits.
But that is a residential school.
My
Where
lord,
Ramakrishna Mission, where?
in Bahrampur, I believe there are, or in Murshidabad.
Residential or?
No, it can be. He can come down at the weekends.
Why this school is not good according to you?
How
Yes.
come you even say
My lord,
this? I do not follow, my lord.
I made this
This is the
application.
order once.
I made this application
No,
in class 5.
This is where
Class
he
5. I made this application while he was in
may have,
5.
but now he is in class 8.
But
Mr. Doctor, at
but
this stage,
he
why
has
are you
to be
disturbing? If you put him to a different environment, he was
presently,
accustomed to one environment.
presently he is in class 5.
Yes, my lord. He has been
Presently he is in class 5. 8 years of age.
Yes.
Presently he is in class 5. So, my lord, that apprehension probably will not be there.
Yeah,
My lord, the paramount consideration, my lord knows that
Yes.
is the betterment of the child.
Yes.
I wish to get him admitted. I can undertake that I will take care of his entire educational expenses, even the cost of travel. Even the cost of travel.
No, why cost of travel?
Because it may be, he stays at Jiaganj. Around 15-16
Now, my lord,
kilometers.
Jiaganj is such a my lord, developed
15
place.
kilometers will be far off.
40-45 minutes.
But,
Mr.
40-45
Doctor, because he has to study, and you know very well.
But
After school hours, what the students have to do.
As at least as a father, I should try to give the best possible
Mr. Doctor,
avenues
yes,
to my child.
but it has to be near to a residence.
But I will
16 kilometers one way means
subject to-
32-34 kilometers both ways.
Subject to your lordship's kind consideration, if I am allowed to have a discussion with the mother, I can find out a better school
Yes.
in the vicinity also.
Up to 8
Yes, I can.
Sir, if there is a better school, and if the father undertakes to bear all the expenses, after all, you are also interested in the welfare.
If he wants to talk, my lord, he can always talk.
If he wants to,
If he wants to talk to the mother, my lord, definitely, my lord, I cannot stand in the way. But my lord, lordship, my instruction from my client, my lord, is that while this particular child was 5 years of age and she was also there, both of them were driven out in the night. And
these are
so those
presently
don't make these allegations. You will make some allegations. You will make.
I'm not going into that.
These are allegations between the husband and the wife.
I follow.
Now we are between the mother and the father and the child.
Because I was going by the record, my lord.
Now
Because
you also want that your child
yes, of
will get
course.
the best education.
Absolutely. my
So
lord.
if a better school,
doubt of
according to both of you is found out and he makes an arrangement, why are you
But I am
objecting
willing
to
to
that?
I cannot object, my lord. I said that if he wants to talk to the mother, my lord, I cannot definitely object. My lord, if he wants an adjournment for that, my lord, let him do that.
My lord fixes this for mediation. Here we can get this sorted.
Because my lord, my specific
Mediation, if both the parties agree, yes,
Subject
mediation.
to what my
I do
learned
not
friend-
have the instruction about the mediation, my lord. I can just
on
come back
this
to you.
point, only on this point.
I can
Nothing
definitely, my
more.
lord.
Doctor, whether mediation is necessary for
because
if
she
both
may
of you,
say
Mr. I, both of you can have a talk with the, ask both of your clients to come at your convenience at a convenient place. You can have a discussion or through conversation. Now various modes are
Yes, yes,
available. You
we
can
will.
do that.
But they,
Because, my lord, the
we
order
will
will be-
suggest certain schools, they will come up with another, this can
But
go
because,
on.
because this, my lord,
I want a solution on this.
my lord, I just paid your lordship only one thing. My lord, if your lordship sees the petition names a particular school.
Yes.
Now he says
The order also, my lord, appreciates that only. This is why this order is
so
passed.
international school.
Yes, lordship kindly sees the order once.
If you also agree to that, if you say yes, that is a very good school, and you want he is agreeable to be a,
What
why
is
are
the
you
prejudice? I
objecting
do
to
not
that?
know.
I am
What is
not
the prejudice? I do not
So
know.
both of
I
you
am
have a
not.
discussion. So
I do not
2
know what is the.
weeks, 2 weeks,
My lord,
when this petition is taken up for hearing. Call the next matter.
53 my other side has come.
Where is your other side? Please wait. Yes, yes. 50, 50. পরেরটা রাখুন তারপরে 57 53 টা আনিয়ে নিন 53 টা আনিয়ে নিন file has to be brought আনিয়ে নিন তারপর call the next matter
7. This revisional application has been filed.
file এসছে yes
Against the order passed by the learned district forum, my lord. District forum, Howrah.
district forum
Yes, my lord.
yes why are you challenging this there's the provision of appeal
My lord, there is a judgment. My lord, that if
there's an appellate forum
my lord, there is an appellate forum, my lord, there is a judgment that if there is any error apparent on the face of the record, that can be brought before the learned High Court, before the Honorable High Court. My lord.
error
My lord.
what is the error
My lord,
where is the judgment this is against the appellate order this is against the appellate order state commission from district forum thereafter
my lord,
this is
the
not the original
complaint has been filed
Where is
against
the-
a dead person, my lord. The complaint has been filed against 2 dead persons, my lord.
you cannot take that point in the appeal
My lord, I have already taken that point, my lord.
then what happened
My lord, they did not appreciate that because of the fact that the written
appeal
version
is
has been
pending
filed. No, my lord. The matter is pending before the district forum only.
yes where is the order you challenge that order before the appellate forum where is the consumer protection act where is the order passed by the Honorable Supreme Court asking the high courts not to entertain 227 applications against orders original orders passed by the you have not brought that and you are showing me this
My lord, the
Supreme Court order you are not bringing
complaint has
and
been
this is
filed.
also distinguishable
The complaint has been filed against two dead persons.
Take that point in the, where is the Consumer Protection Act? Yes, do you want to withdraw? In view of existence of alternative and
I'm for the opposite party decree holder.
I have already saw
opposite party
decree holder.
Decree holder.
decree holder.
I am for the judgment dated. Yeah.
Yes, yes. 47, section 47.
Section 47.
Section 47.
How many 47s you have filed earlier?
Only one, man.
Only one.
I tell you, Lordship, what happened.
Then it is to be allowed.
No. I know, my lord, there is a point of doctrine of constructive res judicata in the second section 47 application. I bowed down
The
to
second section 47.
the second section.
You said
47.
147. That is
No,
why I asked you.
Previously, I have filed one, my lord.
That is why I asked you. One, because naturally more than 147 applications are filed.
This is the second one, my lord.
What is your point in 47?
My lord, I shall tell your lordship, my lord. Suit for eviction, decree passed, affirmed till the second appeal, my lord.
Affirmed up to the second
Up to the
appeal.
second appeal, my lord. After that, my lord, execution case filed. First 47 application filed on the ground that notice was not served, that was dismissed.
Notice of suit.
My lord. Not
Can you take that point in 47?
I cannot, my lord. That was dismissed. I have not challenged that before your lordship, my lord. Subsequently, my lord, I got to know about the fact that the property upon which that the decree was passed, my lord, that is the Thika property, and civil court is out of the jurisdiction of to entertain the same, my lord, and the decree is void of initio. Challenging that point, my lord, I further filed on section 47 application, which was, my lord, dismissed on the point
It
of
was available to you when the first application was filed.
that was not available to me,
Why?
my lord. At that point of time, subsequently, my lord, I made an application before the Howrah Municipal Corporation, my lord. Howrah Municipal Corporation replied me with the same, my lord. I made an RTA application. Howrah Municipal Corporation, my lord,
What
replied.
prevented you from making an application at an earlier point of time? No, after this, where you will make an application? After this, before which authority?
My lord, after
if the Thika point goes, then which authority will again Right to Information Act?
My lord, appellate authority. If Howrah Municipal Corporation does not reply me.
No. If this Thika point goes, then you have to make out another point in the third 47.
I do not have another point, my lord, before your lordship, my lord. My only submission before your lordship, though, my lord, I got unable to come with the judgments, precedents, if anything, my lord.
What
My
judgments?
only point before your lordship, my lord, scope of the section 47 application precludes the learned trial court below from deciding anything whichever has been already decided or deemed to have been decided. My lord, the interpretation of deemed to have been decided is, my lord, which is either explicitly.
Where is your application under section 47?
My lord, in page number, second section 47 application.
Yes. Which has been.
Page 120.
You have not challenged the first section.
No.
Page 124.
Page 124, my lord.
124, yes. You are a Thika tenant.
I am not a Thika tenant, my lord. The landlord is the Thika tenant who filed the suit for eviction against me. I was the, my lord, tenant.
Landlord is the Thika tenant.
Landlord is the Thika tenant.
So you are a Bharatiya.
I am the Bharatiya.
So even then, eviction under the Premises Tenancy Act is maintainable.
My lord, subject to correction, my.
Not maintainable.
No, subject to correction, my lord. I have the
Thika Tenancy Act.
Tenancy Act, my lord.
You have not brought.
I have not brought.
You are raising the point of objection on Thika Tenancy.
No, my lord.
আচ্ছা আছে West Bengal Thika Tenancy Acquisition and Regulation. Provisions of the Premises Tenancy Act will apply. So even if that is accepted,
My lord, may I pray one thing before your lordship? Only 1 day accommodation for today
what
only.
accommodation?
So I can come with the books and judgments, my
What
lord,
judgments?
regarding
Facts, then judgment.
my lord, as your lordship.
Look at section 8. দিয়ে দিন তো বইটা। Place it loudly.
May I read, ma'am? Incident for tenancies of Bharatias. The monthly and other periodical tenancies of Bharatias in respect of the structure occupied by them on payment of rents to the Thika tenants shall, with effect from the date of coming into force of this act, be governed by the provisions of the West Bengal Premises Tenancy Acts 1997. My lord, in matters relating to payment of rent by the Bharatias and their eviction by the Thika tenants. The owners of
also under that provision.
But my lord, my point is before your lordship, my lord, they have to have filed the application before the Thika controller, not before the learned trial court below, because learned trial court below does not have the jurisdiction under section 8(3) as read with section 21, my lord. That is my sole point before your lordship, my lord. For that reason, I came before your lordship by filing the subsequent application, my lord. Though, my lord, there is a learned trial court below taken the view of constructive res judicata, my lord, but this is well settled principle of law that once the issue has not been decided in the first
Ought to have been taken. You ought to have taken this point.
I ought to have been that is my mistake, my lord. I cannot go beyond my pleadings.
Yes, what do you say to this?
Your Lordship,
Give me the
the first exhibit that we gave, the settlement deed, wherefrom I derive my title, which I say, it clearly states that the area is a Thika property, Your Lordship. They have annexed, it is a Thika Vastu Jomi. They have annexed it at 104. This is the deed of settlement by
That is, they are saying that the civil court do not have jurisdiction for your eviction.
I am asking for eviction of my tenant, Your Lordship.
Yes.
But under the Thika Tenancy Act, I can, Your Lordship. I am being covered.
They say, according to them, it's the controller, not the civil court. This Eviction Premises Tenancy Act will govern, but not the civil judge, but the Thika controller. What is the submission with regard to that?
Your Lordship, however, in this section 47, Your Lordship, this section 47 application, they could not have taken this.
Degree nullity. Nullity cannot be taken.
It can be taken, Your Lordship, had they not.
Degree is nullity.
Had it
Court
been a
did not have jurisdiction to.
Had it been a subsequent event, Your Lordship.
Not a subsequent. Court did not have jurisdiction as on that date. When the decree was passed.
In the year of
Passed in
2016.
2016.
So after 2001 Act.
2001.
So yes, Mr. Chatterjee, Mr. Aniruddha Chatterjee is here.
No.
Yes, Mr. Chatterjee. This issue has been decided. Controller, Thika property, eviction, whether civil judge or the controller, it was referred to.
Yes.
Have been decided.
Yes. That's the standard.
What has been held?
Not if it's something between the Bharatiya and Millard the
Thika tenant.
then it will be before the civil court.
Before the civil court.
If it is the eviction of a Thika tenant for some reason, then, my lord, it will be
Ticketed by the owner,
by the owner. Then it will be, my lord, to the
controller. Now everything is in your fingertips, in those gadgets which you are every day. Yes, give it to him. When?
My lord, Tuesday, my lord.
You also did not come prepared with that. And you are placing a document which is against you.
My lord, on Tuesday or Wednesday, any day, as your lordship. Tuesday or Wednesday, any day, as your lordship.
No, I could not follow.
My lord, next week, any day in the
And
next
when?
week, other than
What is the date of execution?
my lord.
Today it was
today
there, your
is-
lordship.
is-
Today it has been adjourned.
No,
No.
the bailiff has given his evidence today.
What is the next date fixed?
It has not yet been given, your lordship.
Yes, call the next matter.
59.
Yes.
Your lordship, we are here for the impugn order, order number 11. We are for the petitioner, being led by senior advocate Sabyasachi Mukherjee. Your lordship.
What do you want? You want time? You want to move? What do you want?
I want to move, and I'm here for the stay of the impugn order, order number 11, dated 25/11/2024.
Order number 11.
Order number 11.
What has been done by that order?
The stay.
Your lordship, we have come against the order number 11 dated 25/11 of 2024, wherein the learned court rejected a stay application against the execution title execution case before the learned court of the junior court of civil judge junior division Bidhannagar. हम यूज कर रहे हैं, ठीक है.
Yes, yes. What happened to the title appeal? What is
Actually,
the
Your
nature of the
Lordship,
decree? What is the nature of the decree?
the nature of the decree, Lordship. Nature decree order कहाँ है? The appeal was, Your Honor, my Lordship, it was dismissed for the default in the order
Yes,
dated.
yes, I'm asking you, what is the nature of the decree? What is the decree for?
Decree order कहाँ है? I'm extremely sorry, my Lordship. We have not been instructed with the nature of the decree order, my Lordship.
Uh,
कहाँ है? नहीं है.
this matter was mentioned by the
মানে 4 PM 4 PM
4 p.m. What happened? What 4 p.m.?
Your Lordship fixed a matter.
They're upgraded matters.
Not
Fighting
urgent.
urgency.
Not urgent. This matter is not urgent.
No, extremely urgent.
Yeah, দেখো 4টার সময় ফিক্স করেছেন জজ স্যার।
What is this matter?
নেই কিছু নেই।
May I?
So your matter.
Yes, my matter, my lord. Kindly at 4 PM, kindly, my lord, takes it up. They. Now,
Walk off that injunction.
Yes.
Strategy, it will take.
That is on 5 minutes. 5 minutes. 5 minutes.
5 minutes for you to make your submission, but it will take half an hour for me to understand your submission.
And then Mr. Galib is also there for
Am
the
I-
work board.
The strategy upgraded motion, can you not wait till the next?
But if I don't wait, my lord, I will not be allowed to go out of the courtroom. Then might as well wait.
Mr. Chatterjee, yours is the next item. Very urgent.
हमारा तो बहुत urgent है।
Payment for what? No, that you are for the opposite party. Who is for the petitioner? None of them are here.
See, because they don't have interest. Because they don't have interest. In my matter, my lord, my other side is here. My other side is here. The Mr. Galib is there. And I will take 5 minutes just to show me that there is no.
Only 5 minutes of time.
Yes.
So, Mr. at 4:25 it can start.
No. আমার মামলা তো।
CPM. Mr. Chatterjee, only difficulty is huge number of motions are there. I have no difficulty. Your other side has come from behind is watching. So, but the only difficulty, I appreciate that, but the motions will get stuck. You have seen the list. What is the pressure of motions? That is why I'm trying, and I'm also upgrading the matters which cannot wait. This is how I'm trying to accommodate. But heavy matters, if it is taken up, that is why I thought I could reach by 3:30 or 4. But now these motions, upgradations, you don't know in the Wednesday in the morning, I will request you to come for 1 or 2 minutes, Wednesday at 10:30. Any Wednesday at 10:30.
I don't think that is not calculated in your years. If I am not coming.
That is the difficulty. So That is the reason for this upgradation. And you see, when it has been upgraded, not ready.
My lord, every 4 PM matter, my lord, line the senior advocates are there.
I know that. That is why the time has been fixed for that. Mr. Chatterjee, I can do one thing. You can start from 4, after 4:30, you can continue. I have no difficulty on that. I'm not difficult. I have no difficulty. If you agree to some.
Start now and end at 4:30. I should start now and end at 4:30.
That can. If it starts at 4:25, I will conclude at 4:30.
Yes, Mr. Kormakar, tomorrow?
Mr. Kormakar, tomorrow.
Upgraded matters. Can it wait till tomorrow, other matters?
My lords, if I may be.
Yes.
My lord, item 69.
Will
I
take only
understand,
5
my
minutes
lords,
of time. But it's
there's
not
an
that urgent,
urgency, my
cannot
lord,
wait for
because
tomorrow. But if your lordship wants it to be taken up tomorrow, I am no difficulty.
So it will appear tomorrow also.
No, tomorrow,
subject to your lordship's indulgence. If it can be accommodated either tomorrow or Monday, my lords, I've got my Bombay matter fixed on next Friday.
So you want it on Monday?
My lords, if it is tomorrow or else Monday.
Let it appear on tomorrow.
Yes, my lords. My lords, if your lordship may permit me at least to mention before your lordship around 2, I will take my chances.
All right.
I'm grateful. I'm indeed grateful.
May it retain its position.
It will retain its position. Subject to the new motions, your inter-se seniority will be there. That will not be disturbed. Inter-se seniority will not be disturbed. Yes, Mr. Chatterjee. দেখুন এই 4টের সময় যে ম্যাটারটা tomorrow is the date. Then it is to be taken up. 60. Yes, Mr. Chatterjee, 62 and say tomorrow is the date for execution.
So that I make myself ready and close.
You are always ready, Mr. Chatterjee, with your matters. Fixing, let it appear, it will be taken up serially. If that matter is ended on Monday, yours will be on Tuesday. And even if it is not ended, Mr. Chatterjee will not do in the following day. I can assure you with regard to that.
109.
Yes, call 62.
109, can order be passed that you got to file a supplementary affidavit. Subsequent event has come.
109. In Mr. Chatterjee's matter.
Yes. Thereafter. Yes.
Mr. Basu, you make your affidavit ready.
Subsequent event.
I do not know if Mr. Chatterjee do not have any objection, I can grant him.
Granting leave a subsequent
Then I have to consider. Mr. Basu. You can prepare, Mr. Basu, you can prepare your affidavit on that date. If I grant you leave, that can. Otherwise, if Mr. Chatterjee does not object, I can give you leave. I do not know what is his objection. Yes, call item number 62.
Yes, my lord. 62
62,
and
yes.
63 my lord are connected matters, my lord. May I just quickly submit, my lord?
Because tomorrow is 3:30.
Why? Mr. Basu says no, there is no 3:30 tomorrow. Mr. Basu, tomorrow there is 3:30.
Why from the secretary got that permission? Ask Mr. Chatterjee.
Yes.
My lord, here the impugned order, my lord, passed by the National Commission, my lord, exercising appellate jurisdiction.
Yes.
My lord, your lordship is aware of, my lord, the Supreme Court held, my lord, the jurisdictional High Court, my lord, will exercise jurisdiction of the order passed by the National Commission, my lord, exercising appellate jurisdiction, my lord. My lord, here the, my lord, matter pertains to, I am the owner of a hotel, my lord. A fire broke, my lord, on 31st December 2014, my lord. There, my lord, an unmarried couple, my lord, died. Now, my lord, the State Commission, my lord, proceeded on the premise solely relying upon the police report, that is FIR and charge sheet, that adequate fire extinguisher or fire equipment was not there. and there was an electrical short circuit, and there was a deficiency of service. Against that, I challenged the order before the National Commission. National Commission also, my lord, held upon the police reports. Though the trial is going on, none of the witness has come up. The trial is pending. I will show from the charge sheet and FIR that the police, it is only the police held that the sufficient fire equipment was not there. Though the contrary evidence are there, fire authority in its report held that reasons for fire was uncertain, and second, I had a valid license which was renewed at the time of incident. It was valid till 2015 March, and the fire broke out, my lord, on 31st December 2014. My lord, may I just draw your attention, lordship, one document.
No, show me from the infirmity from the impugned order.
Yes, my lord. My lord, may I
Show me.
show? My lord,
What is
kindly.
the infirmity in the impugned
Yes,
order?
page 20, my lord. Page 20.
Page
Page
20.
20. Yes, my lord.
Yes.
Page 20. My lord, kindly come to the observation part. My lord, paragraph 11. Paragraph 11. In the instant case, it is undisputed that on 30th December 2014 at so-and-so, there was some electric disturbance at the Yatri Hotel and the matter was brought to the knowledge of the management. However, no action was taken up. This was not part of the evidence. It is not in dispute that at about 1:15 a.m. a fire broke out in the Yatri Hotel premises engulfing the hotel, which led to the death of the complainant's son and his friend in the said incident. The post-mortem report clearly brings out that the deceased suffering major burns throughout the inside the body, which led to death. The main ground on which the impugned order dated 8 February 2021 is assailed is that the State Commission relied on the charge sheet to come to the conclusion that the Yatri Hotel was negligent. While it is settled that fact that the charge sheet is not conclusive proof of guilt, however, the undisputed fact that the emanate from the documents can be used to arrive at conclusions in matters that do not require strict evidence as in criminal law. In the instant case, a perusal of the charge sheet clearly shows that it mentions the reports of the incident from authorities other than the police. Then the observations made by the police in charge, my lord, in the charge sheet, my lord, was quoted. May I place that during investigation of the case, it is found that on 31st December 2014 at 10:30 hours, there are some electrical disturbance at Hotel Yatri. The matter was informed to hotel management, but no action was taken that time. Later on, at around 1:15 a.m., fire broke out and engulfed the hotel and ultimately resulted deaths of 2 individuals. Owner of the hotel were control of the entire system, so they had liability to ensure that the entire system is working properly. Mere installation of the fire safety system and obtaining the fire safety certificate does not discharge the person in control of the systems from the liability to make sure that the entire systems are working properly. It is clear that all owners of the hotels have the liability to prevent such devastating fire, which resulted health of 2 persons. During investigation of the case, expert team of FSL Kolkata visited and inspected the spot. Officials also visited the spot. WP Fire Emergency Services also inspected the spot also. Later on, reports have been collected from these authorities. It is to note that the so-and-so Siliguri fire station initially reported that inbuilt system for fire lighting had been installed but not functioning despite of obtaining NOC from fire service. My lord, I will show from the record this prima facie observation is by the police authority, my lord, contrary to the fire by the report submitted.
Show me your evidence.
Yes, my lord. Kindly take, my lord. Kindly come to page 141. Kindly come to page 141. My lord, kindly see, this is the fire authority writing to the inspector in charge.
Page 141.
Yes, 141. My lord, kindly see, with reference to subject noted above, the undersigned has to inform his kind and that the license was issued in favor of the above noted hotel in provision of West Bengal Fire Service Act 1950. In this regard, it may be mentioned that this query for information from 1 to 6 are in affirmative. Necessary photocopies in these regards are enclosed herewith. My lord, the copies of license, my lord, appearing, my lord, kindly see the year 2014 and 15.
This is, you may have license.
Yes, my
But
lord.
show me what steps did you take at the relevant point of time when the fire broke out? Maybe there are instrument, equipments. What
Yes, my lord.
steps did you take? Show me that.
My lord, the fire broke out at night. Now, my issue before your
You
lord.
don't have any duty if the fire breaks out at night. What you took, what steps did you
My
take?
lord, I have taken all reasonable steps.
Show
My lord,
me.
I am supposed to, my lord.
Proof that you have taken all steps.
My lord, that is the
Maybe
matter.
there are fire extinguishers, maybe that you have certificates from the
My lord,
authorities.
here, my lord, what
That does not absolve you.
what the both authorities, my lord, did. My lord, both state commission and the national commission, my lord, solely relied upon the police reports, my lord, and nothing else. My lord, these observations were not made by the police, by the fire authority upon inspection. My lord, I will show it from the record. My lord, I have annexed everything.
Show me the inspection report of the fire authorities after
lord.
this fire broke out.
Yes, my lord.
And what steps did you take?
My lord, may I place, my lord, one document from charge sheet, my lord, one paragraph from charge sheet, my lord. My lord, kindly come to page 96B.
Yes. 96B.
Yes, my lord. Charge sheet starts from 96. Page 96. Sorry, 96A, after 96 page.
Yes.
Yes. My lord, kindly turn the page, my lord. Kindly come to 96B. My lord, I am referring the second paragraph. My lord, during investigation of the case, expert of so and so visited and inspected the spot of so and so, also visited the spot by fire emergency. Also, my lord, I have kindly see later on, reports have been collected from the authorities, from those authorities. It is to note that so and so, the officer's name is there. Siliguri initially reported that inbuilt was
Very
firefighting had
difficult
not
to
been
read.
installed.
You have not given a type copy also.
No, my lord, I have given a type copy, my lord. My lord, the type copy is, my lord, is appearing, my lord.
What are you trying to show
My lord,
from here?
type copy is appearing from.
What are you trying to
97.
show from this
My lord,
charge sheet?
from this side. My lord, I'm my humble submission, my lord, is that the police report, my lord, charge sheet is only filed. That is under challenge, and the both authority, my lord, did not solely relied upon the police. I will show the state commission's order as well as the national commission's. Your lordship has seen it, my lord. They have solely relied upon the police reports and nothing else. Absolutely no evidence.
What evidence you have in your support?
My
To
lord,
show what steps did you take? Those fire equipments were functioning. You took the. What is the evidence in
my
that
lord,
regard?
may I, my lord, my lord, show one documents, my lord. My lord, I have shown the documents, my lord, 141. This was addressed to the authority, police authority. My lord, may I show one document, 152, my lord.
Yes.
My lord, this is the finding of the fire authority, my lord, as regards to the fire.
Yes.
Broke out. My lord, kindly see the observations. Office cum receptions room on the first floor, G+4 for storied building, having office furnitures, computers, TVs, furnitures, and also approximately 25 numbers of in the hotel was involved in fire. Fire out 3 years, 3 jets used, and so out of.
This is what steps the
Now, my lord, kindly
fire
see
service
above the
authorities
findings.
took.
My lord, kindly see the finding. Cause of fire at the top, just above the paragraph, could not be ascertained.
Show me that at a relevant point of time, these fire extinguishers were functioning. Show me a document.
My lord, I have taken this point, my lord.
Show me
in the
a
evidence,
document that
my
the
lord,
fire extinguishers were functioning. You have to satisfy the court to show that you are not liable, there was no deficiency in your service. Show the document to show that the fire extinguishers were working, functioning at the relevant point of time. Yes, come on the next day. The learned advocate appealing for the petitioner commences.
Under 10.
4 p.m. matters, my lord.
4 p.m. 4 p.m. cannot be now taken up.
Then, my lord, it will come automatically. It will run.
It will appear. Yes.
And order,
Where is your other side?
He was there, his junior is here, my lord.
Yes.
Kindly take it on tomorrow, my lord.
Yes, yes. What is this matter?
My lord, I have come here telling in the order 7-2, my lord.
Yes, what happened 7-2?
7-2, there is my excess payment, my lord. That aspect has not been considered, my lord.
Excess payment?
Excess payment, my lord. Since 2009, before 2009, I was there, my lord, as a tenant, and 2009, my lord, given me a letter of atonement, my lord, and since January, I am paying rent. Since January, my lord, the present plaintiff has not, the landlord has not paying any rent, my lord.
Give me a minute.
Any rent receipt, my lord.
Has not given, that is your case.
Rent receipt, my lord, that is not my case. And I am also made excess payment, my lord. I have also annexed the bank statements, my lord. And the court bill
Give me a
also.
minute. Give me a minute. When you receive summons?
I have received summons, my lord, duly appeared and file 7172, my lord. There is no
7-1, you have complied with.
7-1, I have complied with, my lord, and
The order says no, you have not filed the court deposit challenge.
my lord, court deposit, there is a direction, my lord, upon me to file the bank statement, my lord. Kindly
What
come
bank
to
statement? After the appearance in the suit, what bank statement will do?
court challenge, my lord, kindly
Yes,
I have
7-1, after appearance, show me that month by month you have paid.
my lord, kindly consider. I have given, my lord, kindly pay 56, my lord. Month by month, I am paying, my lord.
Bank?
No, before the court, my lord.
Yes. Page 56.
onward, my lord.
What is 56?
Page 56, my lord.
Why have you not produced this?
My lord, there is a direction, my lord, kindly come to pay order, my lord. I am giving the order, my lord. There is a direction to only, there was my givens, my lord, that I have made excess payment. Accordingly, court directed me to file the bank statement. Accordingly, I have filed the bank statement. and only showing the excess payment, my lord.
When you appeared, show me your application under section 7.2.
7 I have filed, my lord. The petition is here also here, my lord.
ফেরত দিয়ে দিন যা
Page 27, my lord.
না বলি
P3, my lord. Page
page show me your
27.
application under section 7.2.
7 my lord.
Yes.
P3, page 27, my lord.
Your application is very vague.
My lord.
You have said, I've paid by cash, check, NEFT, everything you have stated.
I have given the bank statement also, my lord, and the application modification, my lord. Kindly come. Page 32 onwards, my lord.
All right, come tomorrow.
My lord.
You are appearing.
My senior is honestly.
কালকে রেখে দেবেন ওই dismiss for default tax কেটে দেবেন recall করুন
My lord, item number 93 and 94, my lord, the interim order, my lord, is expiring tomorrow, my lord. My lord, that matter, my lord, where the warrant was, my lord, stayed by your lordship, my lord.
Yes. What happened after that?
My lord, we have served copy, my lord. It's running in the list, my lord.
93, 94.
93 and 94.
কালকে দিয়ে দেবেন তো extension of interim order heading এ 93 and 94. Extension of interim order. Have you received any notice from who is appearing for the other side?
No, my lord, I'll check the status, my lord, whether any Vokalatnama has been filed. If yes, my lord, I'll serve a notice.
Inform him.
Yes.
93, 94 কালকে extension of interim order. Sure.